Welcome back to the afternoon session of the June 6, 2024 Investor Advisory Committee meeting. I'm Brian Shore, the chairman. Tony, do we need to note any other of our members that has joined or departed since this morning's session?
We will take those down, Brian, and be sure to record those. Thank you.
Okay, thank you. Our afternoon agenda begins with our panel on artificial intelligence, AI regulation, embracing the future, which will be moderated by James Andrews, followed by discussion of two potential committee recommendations. James?
Good afternoon, commissioners, distinguished panelists, fellow members of the IAC, esteemed guests viewing online. Welcome to this critical panel discussion today on the 90th anniversary of the SEC and the 80th anniversary of D-Day, the Allied invasion of Normandy. We gather to address a topic that transcends borders, industries, and the very fabric of our financial systems, artificial intelligence, AI. As we stand on the precipice of an AI-driven revolution, we find ourselves at a crossroads. The rapid advancement of AI has ushered in unprecedented opportunities, but it also presents challenges. Our task here is not merely to discuss the theoretical implications of AI. Rather, it is to grapple with the practicalities of regulating something intensely important, complex, and fast-moving. AI has received intense interest in recent months, with Congress holding more than 40 hearings, President Biden issuing an executive order, the Office of Management and Budget issuing a memorandum, and internationally, the European Union initiating the AI Act and the International Corporate Governance Network publishing an investor engagement guide. The CFTC and the PCAOB each recently featured discussions on AI. One of the current movies on Netflix, Atlas, features a woman versus machine battle. Jennifer Lopez, playing Atlas, has to save humanity by killing the AI humanoid developed by her mother. The humanoid, optimized for good, wants to kill humans to save the planet. So why are we here? The SEC, as the guardian of our capital markets, recognizes that the premises of AI are no longer science fiction. Amazing things are now our reality. From algorithmic trading to digital advisors, to massive data collection and analysis operations, to having AI assistants at our fingertips. AI permeates every facet of our financial ecosystem. Its impact on market efficiency, investor protection, and systemic stability cannot be overstated. Its future uses appear to be bounded only by our imaginations. What is at stake? Market integrity. We must monitor that AI operates fairly and transparently. What should happen when it does not? Investor confidence. Trust is the bedrock of our markets. How can we assure investors that AI-driven decisions are sound, ethical, and aligned with our interests? Systemic risk. Does AI's interconnectedness pose systemic risks? Today, we will discuss some of the important topics surrounding AI, acknowledging that few topics are so broad and move so quickly. Our hope is to move from discussion to making a recommendation on AI in the coming months. Addressing these issues today will be practitioners, academics, and technology leaders, including David Danks, Professor of Data Science and Philosophy, University of California, San Diego. Brian Croteau, U.S. Chief Auditor and Auditing Services Leader, PricewaterhouseCoopers. Diane Jandren, Professor of Accounting, Iowa State University. Richard Kerr, Partner, K&L Gates Law Firm. Andrew Koo, Chief Technology Officer, OWL ESG. Dee Rafay, Founder and Chair, Creating Future Us. For discussion, we will have brief initial statements from each panelist, and then we will move to discussion questions and then questions from the IAC. Beginning for us will be David Danks. David serves on the National AI Advisory Committee. The committee is tasked with advising the president and the National AI Initiative Office on topics related to AI. David, please begin our discussion.
Thanks so much, James. Good morning or afternoon, depending on where you are, and thank you for the opportunity to speak with you today. First, I should say, as James noted, I am a member of the National AI Advisory Committee. Obviously, I am here today in my personal capacity, and I do not speak on behalf of the NIAC or any other members of it. I'm David Danks. I'm a professor of data science, philosophy, and policy here at University of California, San Diego, where I work on everything from building AI systems to the ethics and policy of AI, particularly trustworthy and responsible AI. As James noted, AI is rapidly transforming many aspects of our lives in both beneficial and harmful ways. And these impacts have led in part to calls to regulate, restrict, shape, or otherwise govern AI. The many activities across the federal government are evidence of this, from EO 14110 to the recent OMBM memo. And of course, the challenges of regulating new technologies are relatively well known. AI is only the latest in a long series of technological advancements that have forced us to rethink our laws, our regulations, even our professional norms and voluntary standards. At the same time, AI does present, I believe, some fundamentally new governance challenges, and I'd like to focus on just two in these brief opening remarks. First, AI as a technology is advancing incredibly rapidly. It's sometimes helpful, I think, to remind ourselves that the first widely available large language model, ChatGPT, was released only on November 30th, 2022. That's a little over 18 months ago. And in that time, we've already seen multiple performance jumps from ChatGPT to GPT-4 to 4.0, from Llama 1 to Llama 2 to Llama 3, if we look at the meta open source models, and so on across the space of the large foundation models. Unlike past technologies, we don't have the time to wait and see exactly where the tech leads. By the time we know what the future of AI will bring, it will likely be too late for us to exert significant governance. Instead, we will likely need to use already existing governance and regulatory approaches. I should mention that this is something that we are already seeing steps in this direction here in the US, which is an interesting contrast with the EU, where they've attempted to have an omnibus approach to governing all of AI, as opposed to a more sector-specific approach as we have here. Now, regulations and standards in the US can, I would suggest, be very roughly, separated into those that are outcome-focused and those that are more process-focused. So, as an example of an outcome-based approach, we don't really care how a car achieves its braking performance as long as it succeeds in stopping in time. For the process-based approach, we might consider many cybersecurity best practices and industry standards, which emphasize the way that the system security is designed and tested rather than being outcome-based. Right? Now, I raise this distinction because regulation of AI is actually quite straightforward if we have outcome-focused rules, as those are independent of the underlying technology. The far bigger challenge that we face is when governance depends not on the outcomes, but rather how those outcomes are achieved. Rules designed for AI systems, the present day how, will almost certainly be outdated and irrelevant in very short order. So I respectfully suggest that the governance of AI should initially focus on leveraging outcome-centered rules, regulations, and standards, as those are more likely to be effective and less likely to be outdated before they're even promulgated. The second challenge that I wanted to briefly raise is the way that AI brings new types of capabilities, and so may require entirely new approaches to governance. Another simplistic but useful way to divide governance mechanisms is between those that are object-centered and those that are people-centered. Brake regulations are about the objects. Hiring to non-discrimination is about the people. AI enables us, however, to have systems that fall into a middle ground. I mean, consider the difficulties that many states are having right now about whether self-driving cars should be regulated as cars or as drivers. That is, should we regulate them as objects or as people? Now, in the financial domain, consider the possibility of so-called algorithmic collusion, where two or more pricing algorithms learn, I can explain those quotes if people want to know why, learn to set prices at levels that are higher than the competitive equilibrium. Now, normally we think that collusion requires some kind of intentional coordination by the human agents. In contrast, the algorithms used for pricing don't seem to have anything like human intentions, but they can learn, again in the AI sense, signaling strategies that consistently produce super competitive pricing equilibria. Now, the full story about algorithmic collusion is actually a lot more complicated than I've suggested here. There are many other factors that matter. The point is simply that normal anti-collusion law breaks down when we think about algorithms being engaged in the problematic behavior rather than humans. Now, in general, AI offers enormous promise. I don't want to see its innovation possibilities stifled by overregulation, especially overregulation, which we've seen in some sectors that is prompted by relative ignorance about the capabilities of AI. At the same time, I think we do need to recognize the importance of AI governance. The fact that there are already some tools available for it, in particular outcome-centered regulations and governance mechanisms, but we are going to likely need to build some new frameworks, just as we're doing in other sectors. So thank you for your time, and I look forward to the conversation. Back to you, James.
Thank you very much, David. Next, we will go to Brian Croto for initial comments. Brian formerly served as Deputy Chief Accountant of the Professional Office Practice Group of the SEC. Brian.
Thanks, James, and thanks again for having me here today to take part in the panel. And maybe just at the outset, just a little bit by way of background, as you've mentioned, certainly spent a decade of my career at the SEC, but then the rest of my career at PricewaterhouseCoopers in various roles. I'm currently our U.S. Chief Auditor and Auditing Services Leader, where I focus on quality and enabling and assisting the practice as we think about advancing quality and technology and methodology. Maybe by also way of background, I'll mention that I am on the PCAOB's Standards and Emerging Issues Advisory Group and their subcommittee on emerging issues. And in that respect, today, my views are my own and not necessarily those of the SEAG or anyone at the PCAOB. But having said that, and having spent kind of a third of my career as a regulator and now in my role and spending a lot of time with preparers, I think that there is a lot to talk about. When you listen to David's opening remarks, you think to yourself, there's a lot of excitement here and a lot that can be done, but what could possibly go wrong? And there's certainly a lot of risks to talk about, so we'll get into that. This is an area that I've had a lot of personal interest in when you think about the role of AI as it relates to financial reporting, the financial reporting ecosystem, the role that management has to play, and the role of auditors, whether you're talking about issuers, broker-dealers, or others. There's a lot to think about in the technology and AI space, and particularly as we begin to think about generative AI. Also in a firm such as mine, where we have obviously a multidisciplinary firm, there's a lot that we can learn for our audit practice from what we're helping and learning from relative to our clients in the consulting space, which we are certainly doing and sharing as well. In addition to kind of the personal interest, again, just at the core of what I do on a day in and day out basis relative to methodology with a large team supporting me, we very much focus on methodology and technology being hand in glove, and we're spending a lot of time introducing new technologies, including AI, into what we do as we think about the way we conduct our work. We're also thinking very carefully about what management is doing and how we think about their own responsibilities around books and records and internal accounting controls and ICFR as it relates to the conduct of our audits and as it relates to the introduction of artificial intelligence. Obviously, AI and Gen AI are transformative technologies, and when you think about where we're headed, this is really the beginning of what's going to be obviously a very fast-paced journey, I believe, and I believe we are at a tipping point where we are seeing really the beginnings of introduction of AI and generative AI in ways that we sort of imagined historically, but now we're beginning to see happen much more rapidly. And so I think that's important to think about, because I do think AI will change the way that we live, the way that we work, and certainly the way that financial statements and the like are prepared, and the way that we conduct our audit work. There are risks that come with it, obviously, and you think about, accountability, governance, when you think about completeness, accuracy, reliability, explainability, potential for bias. I mean, certainly there are many risks, and we can go on and on about the nature of the risks. And then the important thing is thinking about having the right governance structure around the use of AI and the right controls relative to controlling for and addressing the risks that result. And also thinking about the appropriate and responsible, and I'll use the word responsible use as opposed to reliance, because I think it's important to think about responsible use of AI and Gen AI in ways that are appropriate for the work that you're trying to do or the tasks that you're trying to accomplish. And I do think that there are easily ways that you can introduce AI in ways that produce unintended results, or it's not really even fit for purpose for what you might be trying to achieve in your objectives. We're proactively, again, engaging with our clients on this front. When you talk about sort of management representations and inquiries and the things that we're doing to try to make sure we best understand what our clients are doing, but in doing that, it certainly informs the way we think about the risks in the financial reporting ecosystem. I also will say I do think there's risks relative to overregulation, notwithstanding everything that I just said, and I do believe that there's a great foundation relative to existing securities laws and requirements for issuers and broker-dealers and others, as well as auditing standards and controls framework, such as COSO, relative to the use of AI. But what I don't think has necessarily happened is as robust explanation as could be useful as to how those rules, requirements, and frameworks apply in the context of the use of AI. So again, back to when you think about either books and records or internal accounting controls, when you think about responsibilities relative to ICFR, and then for auditors, auditing standards and control frameworks for both management and auditors, thinking about and explaining how it is that the use of AI fits in to and is already subject to such regulation and requirements. I'd like to just acknowledge, maybe in closing, the other panelists and the materials, and James, really have appreciated the ability for us to begin to even have some dialogue in advance of this. It's certainly spurred a lot of great dialogue that I hope we'll continue to have here today. And in closing, I'll just say that I stand ready to help, as do my firm, and I'm sure that the SEAG subcommittee, who I cannot speak on behalf of, but I'm sure would be more than happy to do anything we can individually or collectively as the committee here in the SEC think further about what next steps might be. So thank you again for having me.
Thank you much for your remarks, and thank you for that offer of assistance. Next, we have Diane Janvrin. Diane writes frequently on technology-related topics in accounting and recently led an AI bootcamp for accounting professors. Diane.
Thank you very much. I appreciate the opportunity to participate in this panel. I've enjoyed working with regulators, and I've had the honor in the past to present some audit technology adoption research for the PCAOB. I want to start with a little bit of background. I've studied how investors, auditors, and accountants have adopted emerging technology for the past 20 years, over 20 years. I'm going to date myself a little bit. My first studies involved, get this, spreadsheets and how we can reduce the likelihood of spreadsheet errors. And I also did some studies looking at electronic work papers and their impact on audit productivity. That's followed by quote-unquote emerging technologies at the time, realized in XBRL, interactive data visualization, social media, data analytics, textual analytics, cybersecurity, drones, and now AI and generative AI. What I want to talk real briefly about in my few minutes here is talking about some of the similarities and differences between these various types of emerging technologies. Let's go back to electronic work papers. One of the concerns we heard back in that day was, is automating the process, will that result in de-skilling? I think that sounds familiar for us today when we think about AI and generative AI. Is that going to result in de-skilling? Second, let's consider social media. We worried back then about the uncontrollable social media inputs that might negatively impact the markets. Those of you who have been with the Securities and Exchange Commission for a while maybe remember the sudden increase in Netflix stock rise in April of 2013. Investigation revealed that stock rise occurred because the Netflix CEO, Reed Hastings, used his personal Facebook account to announce record monthly downloads. While there's some differences today, we still worry about the lack of control over the inputs and the lack of knowledge about what information is being used to train AI and generative AI. Third, let's go back to the example of spreadsheets, or more recently, we can update that to web pages. I think that most of you would believe that creating a simple spreadsheet or web page is fairly intuitive. How many of you have been like me? I've created both spreadsheets and web pages and proudly pass them on to others, including decision makers, only to discover later on that my quote-unquote end-user computing application, i.e. spreadsheet or web page, contained at least one error. This is an example of what we call in the academic world and user computing overconfidence. This overconfidence bias is researched quite a bit by Ray Panko at University of Hawaii. You want to look his research up. Applying this overconfidence bias to generative AI, I believe we need to think about how users could be overconfident in its output due to its intuitive interface, and then they could get fooled by the inaccuracies and the hallucinations. Just as an aside, we as academics are trying our hardest to teach our students to use appropriate professional skepticism in this AI output. As was mentioned a few minutes ago, I did recently lead a boot camp on AI and generative AI in the future of accounting for over 40 professors and representatives from all the large four accounting firms. Good news is that as investors sometimes worry about the fact that we have some recent material weaknesses in U.S. listed companies due to lack of accounting staff, we are slowly moving in the right direction as far as accounting enrollments. And we basically have concluded that accountants are not going to be replaced by AI, but rather by accountants using AI. And some of our investors, we need to make sure that, investors are not going to be replaced by AI, but investors using AI may hopefully be able to make better decisions. And that's what we need to think about as we do regulations. From the perspective of you as the investor advisory group, I believe we need to remember that new emerging technology will appear almost constantly each day. Users, investors, regulators, lawyers, and accountants will adopt to these technologies. The technology adoption process may be challenging. It may have some hiccups. It may impact various constituents differently. As we move forward through the adoption process for generative AI and AI, I encourage you to think about how AI and generative AI are similar to and different from prior emerging technologies. Remember that despite the technology hype or the technology doom, the future for investors and the Securities and Exchange Commission is bright. Thank you.
Thank you very much, Diane, and thank you for training the future generations.
We try.
Next, we will have Richard Kerr. Rich is a partner at my former law firm, K&L Gates. He co-leads both the financial services and digital assets, blockchain technology, and cryptocurrencies practice groups. Rich has been around this topic for a while, and so I look forward to his comments. Rich?
Great. Thank you very much, James, for that introduction. And thank you to the SEC Investor Advisory Committee for asking me here to speak about this important topic alongside all these experts. I'm truly looking forward to today's discussion. I've been practicing law in the asset management space for just about 20 years now. And prior to that, I was an IT project manager and compliance manager at a large asset management firm. These days, my focus, my practice on providing corporate and regulatory advice to investment advisors and broker-dealers and registered investment companies. But with my prior background in both the technology and engineering space, I've always tried to position myself in the space of advising firms as they integrate new and disruptive technologies. This happens so much in the financial services space. We created a new name for it called FinTech. As a result, of that focus, over that time, I've had the opportunity to work with a number of asset managers and broker dealers as they integrated truly disruptive technologies like Microsoft Office, Lotus Notes, the internet, intranets, social media, email, and just about anything else that's come along the way. Yes, all of these were considered disruptive at the time. Firms were afraid of them, regulators were afraid of them, but yet we were able to integrate them into the process for the asset management industry under existing rules and largely without the need to adopt new rules. More recently, these same concerns have been brought up by things like blockchain and digital assets, and we're working through those. And now artificial intelligence, has burst onto the scene as the newest flavor. This focus in this area has been one of the reasons why I'm at K&L Gates. As a firm, we've always prided ourselves on being at the forefront of leveraging technology and developing tools to improve the ways in which we serve our clients. We were one of the first firms to build out our own internal blockchain in order to allow our lawyers to learn what it is to make a digital contract or a smart contract per se. And we're also, working on ways to introduce AI into our own practice of law. In fact, this past week, there was some press about K&L Gates and one other firm being one of only two firms providing training for summer associates in the use of Gen AI in the practice of law. It's going to be it's going to be a tool that they're going to need to use to be a productive junior attorney in the future. And we're trying to invest in that now so that we get them up to speed. But obviously in the legal space, introducing artificial intelligence into our practice is a risk. As lawyers, we're responsible for the advice that we provide to our clients, whether it's machine or human generated. And so we have not done so without building practices, procedures, and protocols that make sure that machine judgment never does replace that of the responsible lawyers involved. In the SEC regulated arena of the asset management space or the securities business and public companies, much the same problem exists. AI creates tremendous opportunities for increased efficiencies in research, decision-making, operations. However, there is a cost. The software product may deliver an answer to a particular investment question much more quickly. However, it may not agonize or give the same weight over the factors that go into that decision that an individual would. And thus, it's unclear that the machine can identify truly what is in the best interest of an investor. Moreover, how do you confirm that AI will exercise the same level of creativity in the production of research that a well-trained analyst might do? The machine can only learn what it's been told. So these questions create the need for balance. The use of AI does not create a new regulatory problem, as I think you've heard me sort of hint at. Rather, much like the use of the other disruptive technologies that I've spoken about, it puts us in the position of constantly applying old law and regulation to new technologies and their use cases. In most cases, I believe that this has worked because our laws and regulations in this area are primarily principles-based approaches that are not prescriptive in nature and reliant on the underlying tools that are being used. An investment advisor, as a fiduciary to its client, is required under applicable law and regulation to provide full and fair disclosure of the facts and circumstances of its relationship with the customer, including the technologies it uses and the conflicts of interest that are inherent in them. And following that disclosure, they're required to get informed consent from the client to that use. These same concepts have been brought into broker-dealer regulation by FINRA and more recently into SEC rules with the adoption of regulation best interest. Moreover, I would posit that a public company is also required to take that same level of care in presenting conflicts of interest and risks to its shareholders and to the market. So lastly, I guess I would say, that the SEC already does have tools in place to oversee the use of AI. We see this in the recent sweep exams related to artificial intelligence focused on the asset management industry. We've seen recent enforcement actions around, artificial intelligence washing, much in the same form of the ESG cases from a couple of years ago, where firms are encouraged to make full and fair disclosure. And if they don't, the SEC has tools to hold them accountable. So I would posit that, that these principles don't need to be modified in order to the context of artificial intelligence. Rather, we need to make sure to interpret them and use them in a flexible way that allows them to be applied to artificial technology. I think if rulemakers or regulators try to adapt new rules each time new and disruptive technologies evolve, they're constantly going to be chasing their tail. Rather, I think we need to interpret the current rules in a way that they can be applied across the asset management industry and the securities business overall in a way that's fair to the market and provides for true investor protection. I thank you all for hearing from me today. I'm looking forward to the discussion, And I cede to James.
Thank you much, Rich. I appreciate your input. Next, we have Andrew Koo. Andrew is the Chief Technology Officer at OWL ESG. OWL provides clients with the data and tools they need to make ESG-related decisions. Andrew.
It gives me great pleasure today to be able to speak with you on the topic of AI. My name is Andrew Koo. As James mentioned, I am the Chief Technology Officer at OWL ESG. I have over 2 decades of experience implementing systems and building teams and technology in a variety of different disciplines. And more specifically, in the past decade, in building AI systems. What I'd like to present to you today is a viewpoint of someone who has been implementing systems in various different disciplines, considering risks and external factors, needs of various different external stakeholders when building these systems. I would like to take a step back and really think about really a few key points. And what I'd like to present first is really, what is AI? And in my view, AI is a set of technologies with a very different implementation approach than traditional software that has very complex capabilities, that's able to solve very complex problems in a variety of disciplines that we apply it to. And so, just to name a few common examples, we have things like identifying conditions in medical imaging, finding relevant information in documents, identifying credit card fraud, generating content, art, even code, and also powering self-driving cars. As you can see, these things are all very, very different. Now, with the emergence of LLMs in the past, as David mentioned, 18 months, I think comes what I view as, finally the exposure of AI catching up to what we've been doing for actually quite some time now. A lot of the development of AI has not been overnight and has been something that has been progressively developing. And with that comes often a set of misconceptions. And so I just want to talk a little bit about what AI isn't. So AI currently is not generally intelligent. It is not self-learning and not creative by itself. Often, AI may not always be correct too, even if with extensive training. As you can see, AI is incredibly powerful, but at the same time, it isn't a silver bullet that solves all problems and doesn't necessarily solve problems in the way you may want it to. And so, having presented that context, I'd like to present 4 ideas and 4 key considerations to think about when thinking about AI. The first is AI is a technology, and not unlike other technologies previously, as mentioned by various different panelists in recent years. AI systems vary drastically and are not equal, as I mentioned previously, and it's really necessary to focus on the outcomes and assess the risks and external effects these systems have. AI is what you train it to be and may not be what you don't train it to be. And AI is rapidly changing. And so I'd like to present to you, in the idea of AI being a technology solution, 2 systems. One, both of them claiming that they're able to solve math problems with 100% accuracy. It is revealed that one system is a very basic algorithm-based system, and the other is an AI system-driven system. In the case that it's able to provide the 100% accuracy it claims, should they be treated differently? Now, let's change that up and assume that the 2 systems are not able to provide the 100% accuracy it claims and are able to only provide 60%. This applies to both systems. In this failure scenario, should they be treated differently at all? I think it's very, very important to think about this because, in this scenario, we're considering the same sort of technology in a black box system. But if you really think about it, there's self-driving cars, and then there's scenarios such as document systems where the concerns are completely different. For self-driving cars, we may be considering actions of safety and adhering to laws surrounding vehicle operation. And for a document system, you may be thinking about accuracy and bias, and also privacy concerns of the content of the document. What's really interesting is that regulations and guidelines already exist within a lot of these disciplines where we apply AI to. However, I think it is crucial at this point in time where we start extending these regulations to consider the outcomes and risks and the failure scenarios of AI. And I think the more we discuss this, the more we would be able to hone into the actual crucial points where we need to consider. So AI is what you train it to be. As an implementer, it is incredibly important that we define goals and guidelines and policies surrounding AI systems that we implement, and be able to put constraints about what it should and what it should not do. This will enable us to monitor what the actions of the AI systems would perform and allow us to verify that the behavior is what we want. It will also enable us to audit where it is critical for certain types of behaviors for the AI systems. In addition to that, I think having a well-curated and well-understood data sets, along with best practices surrounding explainability and interpretability, will ensure fairness, transparency, and accountability for people implementing these AI systems. And last but not least, I think it's incredibly important to acknowledge how quickly, as the multiple panelists have mentioned, AI is rapidly changing. The best practices, the supporting technologies, workflows, and methodologies are all changing at the very same time these AI systems are changing. And I think it is crucial that any regulations and guidance surrounding AI keeps flexibility when considering how fast this rapid growth is and to not hinder its growth. I think continuous adoption of the latest best practices from an implementation standpoint is going to be critical so that we do not implement ineffective and outdated strategies in governing AI. Thank you so much, and I look forward to our discussion.
Thank you as well, Andrew. Our final panelist is Dee Rafay. Dee operates out of the UK and focuses on responsible tech innovation through her organization, Creating Future Us. Dee is also the first person I've talked with in depth about AI. So I'm looking forward to hearing your comments, Dee.
That's a mantle to carry, James. Thank you. Thank you for the opportunity to discuss this really fascinating topic and how financial regulations can navigate the rapid advancements in AI, as many other panelists have mentioned, and ensure the responsible adoption of these technologies in the financial industry. My name is Dee, and I chair Creating Future Us, a not-for-profit. My background encompasses decades spent across tech, finance, and investment, resulting in an ability to have a technical understanding of AI developments married with a grasp of how that can affect financial intermediaries and investors in particular. I established Creating Future Us to empower investors in advancing a responsible digital economy, as we call it. As all sectors rapidly digitalize and automate, capturing the immense value of this transformation also necessitates vigilant management of attendant risks. CFU's research and engagement tools allow investors to gain deeper insight into these pivotal risks and opportunities during a time of swift tectonic change. We arm investors with top-tier research, astute questions, and best practices toolkits, all based on gold standard frameworks. As companies across sectors increasingly adopt AI, investors face a complex set of risks that can have significant implications for portfolio performance. These risks can manifest in 4 key areas, although a more exhaustive list is in the presentation attached for this panel. The first is legal and regulatory risks. Companies that fail to use AI responsibly or comply with existing regulations could face costly litigation, regulatory fines, and reputational damage. For investors, this means that portfolio companies' AI practices could lead to significant financial losses and decreased shareholder value. Investors need clear guidance from regulators on how existing laws and regulations apply to AI, as well as mechanisms to monitor and assess companies' AI-related legal and regulatory risks. The second is reputational risks. AI systems that perpetuate biases, discriminate against certain groups, or violate privacy norms could expose companies to severe reputational risks. In an era of heightened social awareness and stakeholder activism, companies that fail to address these issues proactively could face boycotts, negative publicity, and loss of customer trust. For investors, this means that portfolios companies' AI practices could lead to decreased brand value, lower sales, and reduced competitiveness, ultimately impacting shareholder returns. The third is workforce and consumer risks. As companies adopt AI to automate processes and make decisions that affect employees and consumers, there is a risk of disgruntlement and backlash if these systems are not implemented responsibly. Employees may resist AI systems that lead to job losses, increased surveillance, or unfair treatment, while consumers may reject AI-based products and services that are seen as invasive, biased, or untrustworthy. For investors, this means that portfolio companies' AI practices could lead to decreased productivity, higher employee turnover, and loss of customer loyalty, all of which can also negatively impact financial performance. The fourth is system risks. As more companies adopt AI, the aggregate effects of these systems could create new systemic risks that are difficult for investors to identify, let alone manage. For example, the widespread use of similar AI algorithms across industries, or even the economy as a whole, could amplify market volatility or create feedback loops that exacerbate economic downturns. Additionally, the interconnectedness of AI systems could create new vulnerabilities to cyber attacks or cascading failures that could have far-reaching consequences for investors' portfolios. To address these risks and protect investor interests, it behooves financial regulators to take the following actions. Develop AI-specific disclosure requirements that provide investors with clear, consistent, and decision-useful information about companies' AI practices, risk management strategies, and governance mechanisms. These disclosures should cover issues such as algorithmic bias, data privacy, employee impact, and consumer protection, amongst others, to give investors a comprehensive view of companies' AI-related risks and opportunities. The second, establish a standardized reporting framework for AI governance and risk management, which would provide investors with consistent and comparable information across companies and sectors. This framework should be developed in collaboration with industry, academia, and investor groups to ensure its relevance and effectiveness in meeting investor needs. Importantly, this standardized reporting would serve as a sandbox, allowing regulators to observe real-world outcomes and develop more refined, targeted regulations based on these insights, and remaining nimble, as Andrew just mentioned, as these practices change and they're reported on, while also providing investors with valuable data to inform their investment decisions. And last, fostering cross-sector and international collaboration to address the systemic risk posed by AI. including through the development of common standards, best practices, and regulatory frameworks. By working together to create a more consistent and coordinated approach to AI governance, regulators can help to mitigate potential for AI-driven systemic risks and create a more efficient, stable, and resilient investment environment. In conclusion, as AI becomes increasingly integrated into the operations and decision-making of companies across sectors, investors face a new set of risks that require careful management and regulatory oversight. By taking proactive steps to enhance AI-related disclosures, establish risk management guidelines, empower investors with practical tools, and foster cross-sectoral collaboration, financial regulators can help to create a more transparent, accountable, and sustainable AI ecosystem that benefits companies, investors, and society as a whole. Of course, at Creating Future Us, we're committed to supporting this effort by providing investors with the research and insights, and we look forward with working with regulators and companies to build a responsible and resilient digital economy that works for all stakeholders. Thank you, and I look forward to the questions to follow.
And thank you very much, Dee. Now we will transition into the discussion portion where I will ask a series of questions for the panelists to discuss. First question, how should the SEC balance the potential for AI to enhance market efficiency and investor access with the need to mitigate risks such as systemic instability, algorithmic bias, and data privacy concerns? I think, David, would you like to weigh in first?
Sure. Jumping right into the easy questions. How do we balance risks and benefits? I think that there are a few things that the SEC needs to bear in mind as they're starting on this journey. The first is the importance of ensuring that investor values really are prioritized in the AI systems. I think we all like to think of AI as it's just math or it's just ones and zeros, but there's actually been a lot of work showing the ways in which values are advanced, prioritized, accelerated because of the way the AI systems are trained and developed and deployed. And so I think it's important not to look at AI and think this is a purely technical matter, and so requires only technical solutions. I think the SEC needs to bear in mind the values, investor values that should be lying at the heart of all of the principled approaches, as multiple people have mentioned. The second thing I would mention is the importance of measurement and monitoring. Right now, we often don't know very much about how these systems are built. And for things like algorithmic bias, it's really important for regulators to have high-level information. You don't have to know the details, but you need high-level information about how the systems are designed, developed, and used. I think we've heard that over and over in the opening comments. We need to understand what are the training and deployment data, for example, that are being used if we're going to assess whether algorithmic bias is a risk in a particular, say, investor advisory chatbot. Finally, I would encourage thinking about these issues in iterative, dynamic ways. So rather than thinking about this as, regulation or certification where you get a check mark next to the AI and you're okay to run with it, one of the challenges I think we have around AI governance is exactly that we want AI to surprise us. That sounds weird. Like sometimes you're like, we want to know what the AI is going to do. We actually do want AI systems to surprise us. We just want them to surprise us in good ways. If we knew what we wanted the system to do every time, we would just hard code that. We wouldn't bother with AI. We would use some of those older revolutionary technologies that people have mentioned. But if we want AI to surprise us in good ways, then that means we're going to have to think about iterative governance, where we deploy systems under more controlled circumstances, where we have guardrails in place when systems are initially deployed. And I think here the SEC, even if it's not through rules, but merely through guidance, can play a very valuable role in helping companies sort of iteratively and dynamically adjust what kinds of systems they deploy for which purposes in which contexts.
So any thoughts from any other panelists?
guess David did such a great job there, James. That I would just add, that I think this balancing act is what, firms need to do whenever they're adopting new, whether it's new technology, new business process, new anything. It's what's the plus and what's the minus, and how do we make sure that we're using it in effect, in a way that we can control with the appropriate policies, procedures, and protocols, to do so. So I think, it's a challenge, maybe in this space, because the technology is advancing so fast, to that, protocols may not be able to keep up. But I don't think that, again, I think that's a sort of existing problem for it each time a firm is rolling out technology and on an ongoing basis. So.
Thank you much, Rich. Yes, Brian.
So maybe just adding to that, and you can think about, again, back to where you're using and how you're using AI, and is this operational or is it in your financial reporting? And I'm very focused, obviously, in my role on financial reporting. But when you do think about that, we know today, management auditors know today, what it means to think about the risks to reliable financial reporting and the introduction of AI, whether that be in your operations, whether that be in controls, whether it be in developing support for your books and records, all introduce different kinds of risks. And the key, I think, here as you think about this is that the degree of experimentation ultimately towards more implementation and use within the development of the right controls is a way to think about this. So there would be some degree of redundancy, perhaps, and then maybe David's point, like surprise is an element of what you're looking for, because you want to learn and identify new and different things and actually do things differently. So you'll expect that you'll learn things that are new and different and be surprised at times, which is good on the one hand. On the other hand, you need to still be able to ground sufficiently in what you know, and periodically, in the context of financial reporting, often be sure that you're still grounded in what you expected and you're achieving the objectives that you're expecting by the use of AI. And so, I think it really is critical to think about what you're doing, what the level of precision is that's necessary, what the risks are ultimately of failure, and then making sure you've got the right governance, the controls, and around that, and that you're responsibly using. I'll come back to those two words, and different people may have different frameworks for how you do that. We certainly have one that I included in my slide deck on slide 5, I think it is, but responsibly using AI in a way that is appropriate for the application, that is fit for purpose in that circumstance. And I think there is a lot of excitement around this, and I also think there'll be a lot of learnings. The key is to not get to a point where we're spending more time fixing problems we created by using AI, but instead preventing them to begin with, or learning and being better in the first instance. And so, but we will learn, and it's important to allow ourselves to do that with the right controls and safeguards in place around it.
Yes, Andrew.
I think this is where, a certain level of disclosure, depending on the type of risk, is going to be incredibly important. It's going to be very different depending on the type of risk, but understanding where that risk is coming from is going to go a long way. So for private data privacy, for example, what data does your AI have access to, will almost immediately tell you, to an extent, right, where the risks could be. And I think that is where, as part of the implementer, right, the preemptive disclosure is going to really help.
Thank you much. For the next question, in view of the expected ubiquitous use of AI throughout the economy, how can investors gain transparency into any risks arising from this systemic exposure? How can companies that innovate AI disclose important risk parameters? And how can companies implementing or deploying AI equally disclose where they get problematic use cases? I'll give this question first to Dee.
Thanks, James. Actually, can I come back to your prior question? Because I think there was something really important there in terms of this idea of sandboxing and being nimble in a fast moving space as a regulator, because one of the things about best practices is that they are soft laws. And that means that they can be experimented with a lot more. There's more ability to iterate. Whereas regulations, by their very nature, take time to pass and then to implement with an industry or a sector. And then it's hard to go back and change them very frequently. So one of the key things we've been thinking about is how can these best practices frameworks give us the feedback mechanism, give us the transparency and information to keep iterating those best practices. So by the time the regulator looks at these things and regulation comes, it's learned from what works and what doesn't work. And so I think it could be a great front runner in a way to harder regulation, a softer regulation. But back to addressing your question, I think investors face a significant challenge in gaining transparency into risks arising from this ubiquitous use of AI throughout the economy. As AI systems become more complex and integrated into various aspects of business operations, it becomes increasingly difficult for investors to identify and assess the potential risks associated with their technologies, especially on a global portfolio-wide basis. To address this challenge, I think there's a multifaceted approach that's necessary, involving collaboration between investors, companies, and regulators. And first and foremost, companies that innovate AI must take a proactive role in disclosing important risk parameters, as Andrew has pointed out, associated with their AI systems. This could include information about data sets used to train AI, the level of human oversight and control, the potential for biases or unintended consequences. So that's for the innovator side of it. One way to achieve this is through the development of standardized AI risk disclosure frameworks, so that not every single company has to go out and think about it themselves and iterate the whole process over and over again. At some point, that's useful. I think at another point, it's better to standardize because the cost of doing so independently for each company becomes overwhelming. So these frameworks can provide a consistent set of metrics and indicators that both companies can benefit from to communicate those risks, but also for investors to see apples to apples rather than seeing different kinds of feedback there. I think similarly for companies implementing or deploying AI, they also ought to think about being transparent where they see problematic use cases or potential risks. And again, this is where you see things like biases in maybe drug development because the data sets are biased somehow. And they've been, drugs have been tested on a certain kind of profile, but now going forward, we need a wider stakeholder involvement. So this is like a very use case specific concept, and only implementers will be in that position to make that evaluation. And for them, this could include disclosing information about specific applications of AI within the company, the governance mechanisms in place to oversee these systems, and any identified risks or challenges associated with their use. So by proactively identifying and communicating these, companies can demonstrate their commitment to responsible AI deployment and help investors understand the impacts. So regulators have an important role to play here in promoting transparency and managing systemic risks associated with AI. And this could involve developing these guidelines and risk disclosure type frameworks.
Thank you much. Yes, Brian.
Can I, so just to add maybe to that, and maybe going back to the point about the risks to overregulation at the same time, and I would fully support and agree that degrees of transparency relative to how different technologies are used, including Gen AI, can be very important and useful, particularly as it relates to matters that are operational and matters that have more significance to an entity. And on the one hand, on the other hand, as many of us talked about at the outset, technologies are evolving rapidly. The use of generative AI and machine learning continues to evolve rapidly. And you can envision change within entities evolving rapidly, and disclosure around that. You might think about, are there thresholds at which you begin to think about risk, and then you think about where it might be more important to have disclosures about how technology, including generative AI, are being used, because you could otherwise envision getting to very lengthy disclosure requirements if you sort of get into all the places within an entity that and I'm not sure that that's what anyone was suggesting, but all the places within an entity that generative AI ultimately may be used, or even other forms of technology. And it also raises the important point of making sure we all are talking about the same thing. And I think this was really a point about generative AI as opposed to other forms of artificial intelligence or technology that we're talking about really here in terms of the disclosure. But all of that would be really important, because you could otherwise see a very prescriptive sort of requirement that could be established about disclosing all of some form of use of AI, which could go far beyond what would be necessary, useful, and productive. On the one hand, certainly understand where it presents sufficient risk or is important enough to understanding the use within the company. It'd be probably beneficial disclosure.
Thank you much, Brian. David?
Yeah, I just wanted to sort of build on this and note that I think one place that the SEC and the Investor Advisory Committee could provide a real leadership is in thinking about the aspects of disclosure that are needed when we recognize the ways that AI systems are increasingly interacting with one another. So when we think about disclosure, we often think about the disclosure of this AI being used by this company in this purpose, but we're increasingly seeing AIs communicating across companies. And as we know from flash crashes and automated trading systems, the risks from one of these systems is not the same as the risks that arise when you have many of these systems interacting. And I think as a sort of governance community broadly of folks thinking about AI, I don't think we yet know what we should be disclosing in terms of the possibility of risks from interactions between AI systems. And I think that's a place where, broadly speaking, lots of us would benefit if there were some guidance about, here's what you need to say if these systems are going to interact with one another.
Thank you. And yes, Rich?
Thank you, James. I think it's a fascinating discussion. I wanted to note, when you were asking the question, I think I heard you say, how can investors gain transparency into any risks that are associated or with the systemic exposure? And I thought, geez, that's a really, really, really broad term, because I think, we always try to think of, full and fair disclosure of the identified risks. And that's I think it's a key point, is that, and I think David was just hitting on it, is that we're not sure we know, other than that there is a risk of different AI models, talking to each other and engaging, and perhaps, but we don't know what the risk is just yet, from that, and we don't know what we need to disclose. So I think there's further analysis that needs to be there. But I do think that, any SEC regulated company or any other company that's making use of AI in any, material manner, should have a, a manner of, assessing and understanding the risks inherent with that, and that AI, and demonstrating or disclosing it to the stakeholders, whether they be shareholders, clients, consumers. Generally, it's really important. I like the idea of, sort of a standardized set of risk disclosure around AI. But I can tell you, for having worked in in an area where there is a large level of standardized disclosure, it's never one size fits all for anybody, and so that that's going to be a challenge and need to be evolving over time. I guess just to answer the last part of the question, I think firms, whether there's a rule in place or not, any firm that is focusing on or using AI right now should not be doing so in a vacuum, and really should have a governance framework in place, right? We need to talk about sort of tone from the top, from the leadership. What principles are they going to use in determining whether they deploy the software? How are they going to comply with their regulatory and legal obligations around it? What's the risk, risk management oversight of it? How are they testing to make sure it's working? All of that needs to be in place up front, as opposed to, waiting for the mistake or the error to happen. That's when we're going to get, firms are going to have real challenges. So I think, in when we counsel clients or when I counsel clients, I speak for myself, not the firm, and they ask me about deploying AI in their business. I say, great, let's talk about what it is, what it's going to do for you, how you're going to control it, how are we going to oversee it. And I think firms should be thinking about that now, regardless of whether there's a specific rule in place or not.
Thank you. Thank you very much. We'll move on to the next question, and I think I want to go to this one. How is artificial intelligence reshaping the landscape of human capital within the financial sector? How do humans keep up, particularly in terms of employee roles and skill requirements, and what regulatory measures should be considered to manage these impacts effectively? For this one, I'd like to start off with Diane.
Okay, I'm going to do something that Dee did a minute ago. I want to make one more point on the last one, and then I'll continue on. Sorry about that. My question or my thought on this the last one, we were talking about a systematic risk framework and developing one just for AI. And I think that at this time, right now, I think we do have some frameworks of talking about risk management. Some of the terminology Rich was using a minute ago was talking about the COSO framework that auditors use right now. Tone at the top, that was a term there, etc. So I think there are existing risk management frameworks that we can use at least temporarily. I mean, we may need to improve them, we may need to modify them, but I just have been hesitant to get into a situation where we either, number one, wait until we develop one, which isn't going to work, or number two, several different people develop risk frameworks, and then you're trying to figure out which one's the standard one, and that causes some trouble. So that's just my point on that. Back to this next question here, James. How do humans keep up with AI in the financial sector? So I'm guessing this is taking a look at our investors. And I think the investors, obviously, the Securities and Exchange Commission and other people are going to be involved in training and educating those investors as far as what is AI doing and how it's can it benefit them and how it could also involve risk. There's two other things that I think individuals or humans need to think about when we talk about AI. One is curiosity. Because there is, curiosity is what are the outputs and are they going to make reasonable sense? Maybe curiosity and my professional skepticism or critical thinking appointment I'm going to make next and go together. Because curiosity, okay, well, that's a cool output. Then the second question is, does that make reasonable sense? Is it critical thinking skills, professional skepticism of those outputs? So I think those are things that we need to think about as a group of investor advocates going forward. Some of the changes as far as the roles of employees based upon AI. One of the things that we're hearing a lot, and we're even seeing it in our academic world, etc., is that the responsibilities of people are going to change because there are going to be more critical thinking involved, more communication skills involved. We're already working at the academic level to increase our critical thinking skills, our communication skills among our students, and I think that's an important point. I think that's about it for right now. Thanks.
Any additional thoughts from the panelists? Yes, Andrew.
I think, AI is, in a way, the way I think about it is not too different from a human capital perspective from the PC or the internet, where a lot of it surrounds new boundaries of usage of the technology and a productivity booster in that sense as well, right?
Yes.
I think people need to be aware that, for example, if they're putting privacy-related data into the system, what does that exactly mean? I think it's incredibly important that we educate users of AI in the various different exposures that they have by adopting this productivity tool. I do think it is going to change in terms of responsibilities, as Diane mentioned, and I think overall it is going to be a productivity jump.
Thank you much. Dee?
So this is a subject near and dear to my heart because we just finished, well, actually, end of last year, we finished a massive report on human capital and automation, and particularly AI. And we looked at it globally, not just within the US. But I think one of the key things that emerged for us on that is just the upskilling revolution that needs to take place. There are two things on that revolution that we need to still, again, experiment with and refine and be very nimble and flexible with. One is that different types of demographics are going to require different kinds of upskilling. So someone who is older versus a digital native, someone who has certain skill sets versus others, someone that has certain time requirements versus others. There's just a huge amount of experimentation to land at a good upskilling global program, not even global, let's even call it US wide or even sector wide type of upskilling. So that's a big investment we need to make somehow. And, I don't know, some companies are trying to do it individually, but to the degree that governments can create the right incentives to, again, aggregate resources in a more efficient way, or to create platforms that incentivize that kind of upskilling, that would be great. The other thing that I think is important in terms of upskilling is the speed with which AI is moving. In other words, 5 minutes ago, everyone thought their child should be raised, go to college to become a coder. And now we have AI that can code extremely well. So staying ahead of that curve is also a really important preoccupation to have when you are in that upskilling revolution, is just, and how do we create a human-centric sort of evolution in AI to make sure that it's not just about efficiency and productivity and all these other things, and then humans are left to do the not so great tasks. What somebody said on social media the other day, I want AI to come and do my laundry and clean my house, not to write creative stuff. And then it might end up doing the other thing around. I might end up doing the cleaning and laundry. So again, I think this is the kind of thing that would be very good.
Thank you. And David?
I plus 100 on everything that's come before. I just wanted to make the observation that it's important also to remember that not everybody needs the same knowledge. What an investor needs is different from the developer of the system, is different from the regulator. What I teach my philosophy students about AI is different than what I teach my data science students about AI. And so we need to really think about what is the AI literacy that is required by people in these different roles, and how do we provide that education. And here I'll just put in a shameless plug for some of the recommendations that have come out of the National AI Advisory Committee exactly on the topic of AI literacy, and the importance of the federal government, at least in the US, stepping up and taking a leadership role in helping to promote AI literacy in the roles that people need it, rather than viewing it as a one-size-fits-all.
Thank you very much. And I'm going to ask one last discussion question, and then we'll give an opportunity to the committee to ask questions if they have them. This last question is a detailed one. The PCAOB recently held a panel discussion on AI, which included the work of Transparently AI. The company uses AI to review financial statements and assess whether companies have been misrepresenting financials. This is an impressive specific use of AI in auditing. And given the significant possibilities, how might the accounting and auditing profession use AI, and what guardrails are needed at the PCAOB and the SEC? This appears to be a perfect starter for Brian.
Yeah, thanks for that, James. Appreciate that question. So, look, I mean, to me, the use of AI as you're thinking about fraud and error detection can be a really powerful tool. But obviously just one tool. And it kind of goes back to some of the other questions, because some of this you can think of as an incremental tool or accelerator in what one is doing or preparing. But the reason I'm so excited about it, and it also goes to your human capital question, frankly, is that hopefully what this helps with is it helps put the right information in front of the human to make better risk decisions ultimately, and have more informed discussions that are that are informed by better data and better information, better risk assessment, and better insights ultimately. And so I really think it's critical that one thinks about it in that way in the context of auditing and financial reporting broadly. Transparency, I agree, back to is key, but when you think about the opportunities, I mean, the kinds of things we're talking about, you started with things that were sort of like extraction of data more efficiently and machine learning and all of that, but then you move to predictive models, and certainly you've mentioned one as an example, tools that are available like Microsoft Copilot, or what we're using, we call Chat PwC at our firm, which is our secure instance of OpenAI OpenAI's GPT, but those kinds of tools which can allow you to think about accelerating the work that's being done with the right controls around it, the right reviews around it, the right human interaction and involvement around it. We find the prospects of that very, very exciting, and potentially having the ability to make what we do even more effective than what we do today. Over reliance can be a real risk if you're not careful, and so. But when we look at our clients, the things that they're beginning to do and think about as well in terms of what we're seeing in their ICFR, preparation of books and records, documentation, and ultimately in financial reporting, whether it be drafting accounting memos or whether it be more traditional things supporting their books and records, really, I think exciting in terms of the ability to automate and expedite, but not without the right human involvement. Also the right people with the right skills is important as we think about back to the human capital point, like understanding the risks are different when you're using generative AI and understanding that the human involvement and processes need to be different around that from even a review perspective. For example, there's been already a fair amount of talk about the governance structures around it and the like. I've got a couple other slides in what's on the website now on governance and the use of responsible AI and how we kind of at least think about it. So I won't spend a lot of time on that, but if people are interested, that could be useful. Meanwhile, just briefly touching on the SEAG recommendations from an auditor perspective, since you've mentioned those, you can see those also. I think it might be my last slide in the deck. But when you think about it, very, very consistent with the kinds of things we've been discussing here today, and really getting at making sure there's an understanding of the risks, the way management's using AI in their processes and internal controls are ultimately what that gets at. Engaging with management and the audit committee, having transparency with audit committees relative to how AI may be used in the audit, just as there'd be transparency from management relative to their own use, making the right inquiries and getting the right representations from management, and making sure management has the right governance in place from the perspective of their use of AI, and understanding within their organization where AI is being used and how is also important. So again, I just want to come back very quickly before I conclude on this question, James, to the prior question. I really did highlight a couple questions ago the breadth again of the SEC's responsibilities, and it's very interesting because when you hear about here's some of the remarks from different vantage points, how one might think about regulating and how one might think about the governance structure, the controls. Are we talking about, when we're talking about disclosure, even are we talking about the uncontrolled residual risk, for instance, when we're talking about systemic risk, as opposed to what might be inherent initial risk, because those are two very different things. And you can end up with lots of disclosures of things that are controlled by humans ultimately, that don't present new incremental risks. So there's just so many things to think about in terms of where you're coming at this, given the breadth of the SEC's responsibilities and oversight. But I think no matter which kind of angle you're coming at it from in terms of entities or that are subject to oversight, I do think the existing regulation is a great foundation, as we started within the discussion, relative to building upon and having a better understanding, deeper understanding of how the existing regulations apply in the context of using artificial intelligence. So just wanted to kind of come back to that if I could.
Any other panelists? Now is a good time to move on to the IAC to see if you have any questions of our panelists. Yes, Brian.
Good afternoon, everyone, and thank you for your contributions and informative discussion today. So I think a lot of this topic is quickly kind of gets away from people, right? It's a technical subject, it's a complex subject. And we're sitting here trying to think about how to protect people and create the kind of, understanding and transparency that we want. But I wonder if I could get some reaction to what might be an overly simplistic idea, but it has some appeal to me, which is, regardless of anything else we do relative to disclosure, risk controls, governance models over these models, would it be effective and helpful to have any use of AI have to be assigned to a particular human being as the responsible owner and executor of this, or maybe it's a company, but that any negative outcome that is produced as a function of this AI model can be tracked back to a human being that has to take accountability and responsibility. Is that idea workable? Is that potentially effective? Because it has the potential to cut through some of the complexity and yet assign responsibility in a way that might lead to positive outcomes. I'm happy for anyone to just
Okay, yeah, I'm happy to jump in. So, thanks for that question, Brian. I guess I would say in my slide, actually, I think it's slide 4 has our kind of views around governance that would cover exactly what you're saying. I think you're right on relative to having the right roles and responsibilities, the right process and controls, the right monitoring and testing, and communications and training. So all of the things around good governance relative to the implementation of use of AI are kind of summarized in on that slide, and I think go right to the heart of what you're describing. You wouldn't want to sort of let it loose, if you will, within an organization without the right governance structure around it, and the components of it I was just sort of summarizing, if you will, but goes right to the heart of what you're describing. Now, having said that, if you're like in the financial reporting space, like I was describing earlier, that naturally would follow from sort of a COSO kind of view of kind of how you think about your controls and the overall ability to have the right control environment, monitoring, and ultimately control activities. But you could apply that same logic, if you will, and the same needs for governance, whether it's in operations, financial reporting, or elsewhere in the ecosystem.
I think I would give maybe a friendly amendment to the proposal, which is, I think, two things. First, I would say if there is going to be an individual who's named, it's got to be somebody relatively high in the organization. We have seen in other sectors where this approach has been taken, and they've named somebody very low level, such as the test driver in a self-driving car. They're responsible for every bad thing that happens. Well, they have no control over the system that was put in front of them. They're basically the fall guy for anything that goes wrong. So I think the first thing is it would have to be somebody fairly high up. You'd have to have something like a chief AI officer of an organization that is getting that level of responsibility. The other thing that I think gets tricky is, these days modern AI systems are conservatively, I would say most of them, at least 5 companies or 5 different organizations are going to be involved in the creation of them. The model of in one shop, you get everything from data collection to deployment just doesn't work anymore. The systems have gotten too big and too sophisticated. And so I do think that there's a real question of whether it should be one person or whether different aspects of the process should be assigned. Sort of each step in the process is going to need to have a responsible party, and then an understanding, and this goes to Brian's point about a sort of more sophisticated governance mechanism, a sort of way of aggregating across all of these individuals to say, all right, this was a problem in data collection. And so the individual back there is the one who's ultimately responsible. So I think it's definitely the right idea in terms of ensuring that there are clear points of oversight and responsibility. Constructing something that is going to be effective and not just create patsies is, I think, where a lot of the challenge lies.
Which, by the way, to my other comments, so responsibility is important, but by itself not sufficient. I probably should have said right at the outset, which goes to those points as well that David's making.
And can I just add one point as the regulatory lawyer in the room here? I do think accountability and having someone or some group that's assigned to have ownership of the deployment of the AI and ultimately to be held accountable is important. However, I think that it needs to be an organizational responsibility, and to say point to the chief AI officer and say you're responsible for anything that goes wrong within the organization is going to be quickly a way of making nobody to want the chief AI officer role. We saw this several years back when the SEC and other regulators started naming chief compliance officers in their enforcement proceedings. Very quickly, really high level persons who would have been great at the chief compliance officer role no longer wanted that role, or they wanted firms to affect, purchase, liability insurance for them that would cover them to the extent they were held accountable. So I think it's got to be an organizational responsibility. Certainly a senior level person needs to be appointed as being the project sponsor and ultimate decision maker, but we can't, rely on that as being the only, sort of the control.
And I also add a little point to this because we created a framework for investors on this governance concept. And one of the key things is to ensure a responsible culture throughout the business, because, and that does come from the top. So if you have somebody who's very senior, who's bought into this, who makes this a priority, then the culture throughout the organization should reflect that commitment. And there needs to be good work done in order to, the product developers understand. Then there's also important stuff like whistleblowing and grievance sort of repercussion, ability to go up the chain again to maybe a board director or something like that. These are all part of that whole idea of putting a human in control somewhere, of looking for this. So it's the human, but it's all the stuff around as well, like culture and the right processes.
Yeah, thank you. You can see where I'm trying to get to, which is I have concerns about these models with an investment background where not only do people not want to take responsibility for the outcome of the model, they don't even want to try to explain what the model's doing, because of course it's going beyond traditional human understanding and how they're using the variables. So it's just this big lack of accountability, soft mess that I have concerns about. So thank you for those thoughtful responses.
So thank you.
We have 2 more minutes. Dee, you still have your hand up there? Nope. Okay.
Leftover.
Okay. Leslie? You're on mute, Leslie.
Sorry about that. My question is, from my perspective as the state securities regulator, that we see failures of disclosure all the time. And one of the things that I have a question about is, even with financial professionals, sometimes I don't believe that they can really explain sufficiently to the ultimate retail investor what it is that these risks are. And I think that when you talk about this kind of tech, that makes it even more difficult. And when you're dealing with self-directed investors who are just using a platform, I think it almost seems like they would look at these disclosures and think, oh, that's just boilerplate, I don't really need to read them. How do you address that?
You've stumped us, Leslie. I'd say, look, my stab at it is that disclosures always start out being difficult for people because they are a bit boilerplate. And in a way, you can see why they ought to be boilerplate, because having all these different types of disclosures would make for a big headache for anybody trying to interpret them. However, I think over time, the nuance has to come out. And this is kind of to the earlier point we were talking about frameworks and how flexible are those frameworks and how prescriptive should they be. You start out macro, you start out with an intention, a set of principles almost. And as you go down the industry development, you start to delve down deeper and deeper into particular use cases, into particular areas of high risk. And I think you evolve the disclosure there so it becomes more nuanced. And you're learning all the time, how do things land and how do people consume disclosures as well. I think people are increasingly not reading long reports, says the woman who just wrote a 90-page report. But I think more and more things have to be in that kind of more digestible form, where there's like a synthesis of the information. What are the key points you need to know? And then you can delve deeper if you want to and go down the rabbit hole. So for what it's worth, the 10 cents.
Okay. And one last comment?
Yeah, I'll just quickly say, so outside of the financial space, we refer to this as the terms and conditions problem. Everyone just clicks agree on every terms and conditions, and nobody reads them, even when the very first line, somebody did a study, the very first line of a terms and condition was, you promise to give up your firstborn child to the company. And 80+% of people just clicked OK, right? They didn't even read the first sentence of the thing. So in that, outside of the financial space, though, what we've learned is that the key to actually having these terms and conditions be effective is essentially just-in-time provision of the relevant information. So rather than having a giant disclosure report, can you provide people with the information that is relevant at the points where they are making these kinds of decisions and choices? If you can do that, and AI is a wonderful tool to be able to do this more effectively, you can actually empower people in ways that the standard terms and conditions approach just doesn't. So that's a general thought. I don't know how to implement it, but that would be my suggestion.
Okay. Unfortunately, James, I think we've run out of time.
And that's fantastic. I think this is an indication. It's like when technology fails you, humans have to step in to fill the gap. So thank you very much, Brian, for that. I want to thank our panelists, David, Brian, Diane, Rich, Andrew, and Dee. You were absolutely excellent. Regulatory decisions will shape the markets of tomorrow. Let us tread carefully, guided by wisdom, innovation, and a commitment to embracing the future. Thank you much.
Thank you, James, and the panelists and all of our participants for a very informative and helpful discussion. We appreciate it. Our next topic is going to be our recommendations. We have two recommendations. The first one is going to be a recommendation of the Disclosure Subcommittee relating to self-directed investors, and subcommittee member Christine Lazaro and Disclosure Subcommittee Chair Brian Helmer will lead that discussion.
Thank you, Brian. So the title of the recommendation is the recommendation of the SEC Investor Advisory Committee's Disclosure Subcommittee regarding the protection of self-directed investors when trading complex products and utilizing complex strategies. This recommendation arises out of the broader question of whether the current regulatory structure adequately protects self-directed investors. At the IAC's meeting this past December, we looked at one aspect of this question: how are self-directed investors using complex investment products and strategies? And is there more that should be done to protect these investors when they are engaged with these products and strategies? This recommendation is informed by an understanding of the history of self-directed investing and how the space has evolved over the past several decades. Following the elimination of fixed commissions, the growth of discount brokerage firms, and the widespread availability of the internet, investing has moved online. Brokerage firms offer discount services that allow customers to place trades online in a self-directed manner at a reduced cost as compared to the full-service brokerage model. Today, investing may take place on computers or on apps on phones with little or no commission. With reduced barriers to entry, we know that more individuals are opening accounts and trading. One report estimates that more than 10 million new online brokerage accounts were opened in 2020. In a joint study conducted by FINRA and NORC at the University of Chicago, 2/3 of investors who opened accounts in 2020 were new investors. We also know that new categories of individuals are accessing the markets through these platforms. These new investors were younger, had lower incomes, and were more racially diverse than experienced investors who opened accounts during the same time period. And while we celebrate the increased access and inclusivity, we must also critically assess whether the current framework of regulation is adequate to protect these investors. With information conveyed primarily electronically, we must ensure that the disclosure is serving its purpose and is effective. Additionally, it's prudent to revisit the regulations that have been in effect and ask the question, are they doing their job in this setting? Do the newer firms understand their obligations? Are the rules, some of which were adopted when online trading was in its infancy, as effective as they could be in this setting? In formulating this recommendation, the Disclosure Subcommittee considered the discussion we had with the panelists in December. Additionally, we reviewed the questions FINRA has been asking about this topic as well as some of the comment letters submitted in response to FINRA's request about complex products and options. The subcommittee also sought feedback from other members of the IAC and presented the draft of the recommendation to the full committee for its consideration and comments. Following this process, the committee is making the following recommendations. First, the SEC and FINRA should clarify and supplement the account approval process when self-directed customers wish to trade complex products. There already exists a FINRA rule which requires that a firm take an affirmative step and approve a customer's account to trade options. In doing so, the brokerage firm must exercise due diligence to ascertain the essential facts relative to the customer, their financial situation, and investment objectives. This rule requires the brokerage firm to obtain the customer's investment objective, employment status, estimated annual income, net worth, and liquid net worth, marital status, and age. Guidance to the rule tells firms that FINRA reviews the options trading approval standard as comparable to a suitability standard. Additionally, the SEC has told investors that based on the information you provide, your broker will determine whether options trading is suitable for you, and if so, what types of options trading may occur in your account. However, these obligations and expectations are not explicitly set forth within the rule itself. The committee believes it's appropriate that the standard utilized in determining whether options trading is appropriate for a customer, in addition to being set forth in the rule itself, should be the standard that's set forth in Regulation Best Interest. That is, one that assesses whether the account type is in the customer's best interest. Accordingly, the committee recommends that FINRA amend Rule 2360, the options account approval rule, to explicitly state that when approving an account for options trading, the brokerage firm must determine that the level of options trading approved is in the client's best interest. Next, the committee recommends that the SEC or FINRA define the term complex product as set out in the recommendation and adopt rules that are similar to the account approval rules for options if a self-directed investor wishes to trade other complex products. And finally, with respect to the first recommendation, the committee recommends that the SEC or FINRA publicize best practices for firms that offer complex products or strategies. We recognize that this is already being done to some extent, but believe it could be done in a more directed manner and a more comprehensive manner. As its second recommendation, the committee recommends that the SEC or FINRA increase the type and quality of the disclosures made when a customer is engaged with complex products or strategies in a self-directed account. For example, including prompts that slow the customer down slightly and provide an additional decision point or an opportunity to reflect or reconfirm the investor's intent at the time a trade is placed. We believe that this may be beneficial for new investors at this important moment in time. With self-directed investing, risk disclosure often occurs after the trade has already taken place at trade confirmation. This would potentially move that disclosure up slightly before the trade has been executed. This may also act as a check for new investors who may be obtaining information from sources that are not presently regulated, as we heard about on the first panel today. Providing risk disclosure, risk information at that moment of the trade can be an important timing for investors, an important signal that investors verify what they've heard. And it permits the use of technology in delivering that information as the investor is interacting with the firm electronically. Third, the committee supports the continued enforcement by the SEC and FINRA of its rules when firms are not adhering to the standards set forth in the rules, particularly with respect to the options account approval process. Finally, the committee recommends that the SEC and FINRA increase education specifically focused on self-directed investors who are interested in trading complex products and strategies. The committee suggests that firms consider incorporating the educational materials that have already been prepared by the various regulators, including the OCC, the SEC, FINRA, and NASA. Brokerage firms may also consider modeling, for example, the learning center format utilized by the OCC, which includes educational materials available across a variety of modalities. There is some crossover between this recommendation and the next, which will be presented focused on investor education. And with respect to investor education, these two recommendations really do go hand in hand and should be considered collectively. In sum, the committee believes the protection of self-directed investors would be best served by a mix of regulation, enforcement, and education. And I'd like to thank Brian Helmer and Paul Roy, as well as the rest of the committee, for their input on this recommendation. And we look forward to your comments and feedback. And with that, I'll turn it over to Brian Helmer.
Yeah, thank you, Christine. And let me just take a moment to thank Christine for her amazing leadership and originally pulling the panel together and then putting a draft outline of this recommendation out to the rest of us who then could contribute to that. Her process has been both comprehensive and collaborative and inclusive, and I'm deeply appreciative of where we ended up on this. Before I turn it over to get other people's opinion, as you might expect, I am a strong supporter of this recommendation. I believe it represents a very practical set of recommendations, very common sense. We understand the desire of the industry to continue to be able to offer products to people and to not create barriers that limit access unnecessarily. But the reality is that we do need to understand that there are situations where people, for whatever reason, are ending up in investment products that if they truly understood, they would never purchase, that they are fundamentally not suitable to be in those products. And a combination of protection at the industry level in terms of requiring this kind of pre-clearance and vetting and suitability tests, as well as signals to the investors at the time they're making trades, even if they're getting through that process, that this is a little unusual. This investment has unusual types of risks involved to create that reflection and ultimately create a better outcome for everyone. So I'm very supportive of that. I think it's a great combination of things that are being recommended. And the other piece of it that I'm really proud of is how much time it puts into recommending standards and consistency be brought to the way this is implemented. Standard definitions of what's a complex product, consistency in how it's enforced and implemented. That's the kind of thing that ultimately best serves the investing public. And with that, I'll open it up to anyone else who'd like to speak. So thank you, Christine.
Paul?
Thank you, Christine and Brian, Paul Roy, and everybody on the IAC for your time and efforts putting this recommendation together. I'll be brief and just reiterate that these views are mine personally and not those of my employer, but really wanted to, at risk of being redundant here with Christine and Brian's setup of this specific recommendation as well as the next one, really view this through the lens of a yes and, not yes or type of regulation or suggestions here, I should say, that should be considered. And to put it lightly, Christine, Brian, Paul, and others spent painstakingly a lot of time formulating the panel for the meeting back in December, and then the recommendation that we set forth or have to vote on here today. And I really want to laud everyone for using your integrity and really thinking through the trade-offs of these specific recommendations, and that it's not just a single choice that's going to lead to better outcomes. It's balancing practicality, cost, protection, and clarity around a lot of these specific details. So I just wanted to state that I'm very excited to support this recommendation.
Thank you, Paul. Leslie? You're muted.
I am so sorry. I just wanted to say that I support this recommendation. It's been a topic of interest in NASA for a long time, and I look forward to commenting on any rulemaking that would be proposed on this issue.
Christine, can I ask you about the speed bumps, the friction that you referred to? Give some examples, and how do you think it would work, and so that it's not just a pro forma. You click accept, and that's the end of it. Is there a way to make it so that it's substantive? What ideas and what are some of the parallel uses that the committee or subcommittee has come across?
Right. So we did hear a bit about this a couple of years ago. So there were several speakers on this topic at the September 2021 IAC meeting on the panel Reimagining Investor Protection in a Digital World, the Behavioral Design of Online Trading Platforms. And through that discussion, really there was discussion about both speed bumps, lane assist, highlighting for investors you're doing something that's perhaps inconsistent with what you have indicated your investment objectives and risk tolerance is. And really, and I think we're going to hear a little bit about this with the next recommendation as well. The idea is to just slightly slow down the decision-making process and really make it a more deliberative process and allow for to evoke that deliberative mindset during the trading, which we know is sometimes hindered with online trading, given the fast-paced nature of the platforms. And so while this isn't necessarily happening presently with respect to investing, we do see it in other places. I mean, a lot of consumer platforms, you see it before you check out. Are you sure you want to check out? Things like that. And really it is just a momentary stop, think, confirm. And again, an opportunity to add some, to allow for additional risk disclosure, to allow for, oh, maybe I should click the button and read a little bit more about this because maybe this isn't what I thought it was. And the ability to incorporate and embed layered disclosure in a much more seamless way, given that the intent is that interaction will be taking place electronically, either through the app or on a website.
Thank you, Christine.
James?
I do have a number of questions given the recommendation, in part because of the reference to FINRA and the fact that they apparently went through a similar process in Regulatory Notice 2208, and they have a large number of responses. And those responses from self-directed investors are telling FINRA that there's no need to regulate more. In fact, I read one in particular that felt it was condescending that they suggest that FINRA should suggest that he needs to be protected more, and that given that he has the money, he understands what he's doing, and he knows, so there's no need for additional regulation. I think it was mentioned in the letter, and it's noted that FINRA provides substantial guidance in this area already. And other market participants as well have noted that additional regulation on the FINRA side could have some unintended consequences. Those consequences would be a reluctance to create new products. It could be removal of certain people from the market. And it's unclear to me that, with the three-pronged approach, efficiency, investor protection and capital formation, that we might be putting our hand on the investor protection too heavily. And we're attempting to protect a group that has not asked for protection, that they actually want the market to continue the way it's been going. So I'd like to know what consideration was given to those particular aspects, like who are the constituents, who are we serving with these additional regulations?
So just to start with respect to the first recommendation in particular with the regulation, to a large extent, we're actually not advocating different regulation than is in effect right now. The options approval process is a regulation that presently exists. And to a large extent, what the recommendation is asking is that the guidance be incorporated into the rule itself to make it clear to everybody what the present standard is. So not necessarily a new standard, and even with respect to using the different language, the best interest as opposed to suitability. For a long time, FINRA has interpreted the suitability obligation as an obligation to act in a client's best interest. So even by changing the terminology from a suitable assessment to a best interest assessment, to a large extent, we're not actually proposing that firms have a substantially higher or different obligation than presently exists under the rules as they exist today. And so, but to some extent, this should make it clearer to the firms who should not have to go and look for that guidance to understand what their obligations are under the rule. With respect to the additional complex products and adopting a similar rule to the other complex products, what I will say with respect to that is we certainly have not seen firms eliminate options as a product available to firms because the firm has to go through this account approval process. And we often hear that as an objection to do this additional step. It's going to become too costly. We're not going to offer the product. But again, firms offer options products. And there hasn't been any inhibition in making those products available to self-directed investors, notwithstanding the fact that a firm already has to do a qualitative analysis as to the appropriateness of the trading for investors.
So it appears that the industry does believe that there's a huge gap between moving from suitability to best interest, and actually complicates and more so confuses the issue. And so it would really have an adverse impact on the market. And that's what's coming in the FINRA responses from those industry participants who are closest to that particular activity. So I'm trying to figure out in terms of how can we replace their judgment when they're actually, in the activity and using their own money.
Hey, Christine, it's Paul. Can I jump in here?
I thought you might want to.
Yeah, James. I mean, no doubt there are people who looked at the FINRA reg notice and provided comments that, why are you trying to, restrain my ability to invest in complex products? But, I guess the way I thought about it was that, look, these firms have to, when a complex product's introduced, they have to go through a process of deciding, even if they want to put it on their platform, is this a product that at least some portion of our customer base is interested in? I would surmise that when they make that judgment, that they don't conclude that every customer that they have is appropriate for that complex product. And so, I guess where I was coming out was that when you step back and you look at, kind of what's going on in our world, there's a retirement crisis. If anybody's paying attention, people have to make their own decisions pretty much today in terms of how they're going to save and invest for retirement. And as Christine was pointing out, as we talked a little bit about in the Finfluencer panel, where are people getting their information? Who are they relying on? This is a way to get rich quick. Do this, invest in this complex product, and you're going to be okay. And there are people who will listen to that, and they will lose lots of money and not be able to have a sufficient retirement. And so going through an account approval process to me is not that big a burden. I mean, I know that that there's some platforms that will say this is overreach. There are complex product providers that will say you shouldn't do this because they're in the business of generating these complex products. But these products in many cases aren't suitable or in the best interest of certain investors. And so to have to go, the guy that wrote that letter who wants to, invest in a complex product, he can go somewhere and he can get approved. So, to me, it's appropriate to have to go through the process to provide information where the firm makes a judgment that, this you should be able to trade in these kinds of products. So, I don't see it, as Christine pointed out. There are options requirements that are in place. Firms still make options available, and they control, the extent to which an investor can engage in those products. I recognize that defining a complex product, will be an issue. There'll be a process where you have to go through notice and comment to determine the definition of a complex product, what meets that definition. So there's some hoops that have to go through here, but I guess in the final analysis, to me, it didn't seem like an overly burdened requirement to impose.
So, and I do hear you loud and clear. However, the market participants do describe the product as being overly burdened. So the question becomes, I don't trade options, but basically those who do don't have the same issue. So I'm trying to figure out, how do I substitute my judgment for theirs when they're actually engaged in the activity and don't see there's a need for additional regulation?
No, we're just trying to put in place a process, James. It's not, we're not telling the firms will make a judgment. They make judgments on options. They make judgments about what products they want to put on their platform. And so this is extending that. And again, if somebody is their investment objective, their financial circumstances are such that they get in these products, then so be it. We did, as Christine pointed out, we did, take a look at all the comments, the ones that you're referencing by the folks in the industry. And there were things that we did not endorse in this recommendation. There were suggestions that investors often have to pass a knowledge test in terms of engaging in some of these complex products. We thought that was going too far. But having a comparable account approval process to the options process that's in place now, we didn't think was a bridge too far.
Yeah, look, as someone who's gone through the process of getting approved to trade options, number one, if you resent that process, then you just don't understand, how the world works and what we're trying to do to make sure people don't get in over their heads. Because number two, while it is not difficult if you're a suitable investor to get approved, and it is not difficult to trade them, the reality is that the retail public that buys options generally loses. All of the studies show that. It is the option writers and the option sellers that are making money, and the transactors that are making money. So I would just point out that I love that people have the confidence that I don't need this. That's great. And maybe you personally don't. I didn't need someone to vet my ability to understand options either. But I certainly appreciated that a process is in place when a new customer comes to try to trade options, that we have a vetting process that helps protect people who aren't in the right position to be doing something that has a high probability, a very reasonably high probability of losing all of the capital that you put at risk. And I think it's critical that people understand that when they're involved in products like that versus more traditional products where the risk of loss is far different.
And I think I was just going to add, and I think one other way to think about the account approval process, again, it's not saying you're prohibited from trading these products. It's creating a signal to the investor that these products are different and may contain different risks than other products on the market. And you should think about whether or not these are appropriate for yourself. And so it's on some level, it is a sharing of that responsibility between the firm and the investor.
So Brian, as you were saying, there's already a process in place. And so that was suggested in a number of the letters as well, is that it's not like it's the wild, wild west. I mean, there are in fact guardrails in place, and the industry participants are comfortable with those guardrails.
Yeah, well, so you're right. And for options, all we're doing is recommending that we update that we standardize the language, standardize the process, and share it across firms so that different firms are doing the same thing rather than having each firm have to make an individual determination of how to implement the rule. So there's no attempt to change the rule. It's an attempt to more consistently implement the existing regulation. I think the other side of it, though, James, is that while all of that is in place for options, I can buy triple short S&P, ETFs without anything like a similar protections. You don't have to get the protections for that. That's just an ETF. But a triple short S&P ETF is a pretty dangerous product in a world where the S&P has gone up 25% in a quarter. You could lose 75% of your money in 3 months. I mean, that is an unusual product relative to most people's perception of the volatility of ETFs and mutual funds. And I think having an extra little hurdle to jump over or a suitability test similar to options is perfectly appropriate given those kinds of products.
And so the fourth recommendation, I don't think there's any issue with, and I think even many letters reference education was fine. So that's not the issue. But wouldn't education solve the problem that you're talking about?
If you're suggesting that we require some kind of educational process and certification that you've done your homework and can pass a test, I mean, that is a much higher hurdle now. So you're reacting to criticism of one hurdle with the suggestion of a higher hurdle.
No, I wasn't suggesting a high hurdle at all, and I was suggesting that what industry basically agrees to, they're saying, hey, this type of education would be appropriate. I mean, it's easy to agree with that portion. The other recommendations, I think, the people who are actually in the activity overwhelmingly rejected additional regulation. And I'm trying to get over the hurdle in terms of how do we replace them in order to protect them when they haven't asked to be protected.
Well,
on the panel, we heard from investor advocates, and their voice is represented in the comment letters too, advocating for protections for these investors. And so there are investors who do need and have said they need protection. So while some investors have said they don't need the protection, there are others who have said, and those of us who are representing those investors also recognize the need. There is a need for more protection for investors who are engaged in trading these products.
It's common that if you're in a group that needs protection, think of a small child navigating a large urban center, that they don't even know that they need protection in some cases, right? I mean, that's part of needing protection, is that you're not even aware that you need it. So I'm not sure that's a viable argument against providing the protection that seems to be fairly intuitive to me, at least.
But except I wouldn't compare an options trader to a small child in that instance.
I'm suggesting that the knowledge that a general retail investor brings to some of these complex products is not consistent with what you'd need to know to really understand them in a lot of cases. If they are, they'll be fine. They'll pass the suitability test and they'll click, yeah, I understand the risks, and they'll own the products, and everyone will live happily ever after. I don't really see how this is this is not a barrier. It's just an incremental check to challenge investors to make sure they understand what they're getting themselves into and to signal that it's different.
Yeah, and also, James, I think there's been some misinformation out there. People have been told this is, you're gonna, they're taking away your right to invest in what you want to invest in, and that's just not what this is.
Can I ask, and I don't mean to put either of you on the spot, so if you don't want to respond, that's okay, but I'd like to know, Paul and Andrew, if either of the two of you have thought in detail about these questions, because you might shed some light on these questions that might be helpful to the rest of us in voting.
Which Paul?
You, as an advisor,
Yeah.
as you're helping your clients open up an account.
Yeah, I mean, fair.
And thinking about the Reg BI aspect of it, how do you look at it?
Most of
again,
my,
I don't mean to put you on the spot. If you don't want to respond, that's okay.
yeah,
But given your
happy to say,
experience, it would be helpful.
happy to say that my day to day is more at the workplace committee level that serve 401k, 403b pension plan participants that are generally not self-directed, although some have access to a self-directed brokerage account window within 401k type plan. So there are people in plans that we serve that are maybe falling under this lens. And I would say that I strongly agree. I appreciate James bringing certain perspectives that certain people that are self-directed don't want or need, extra layers of protection. But I agree with Christine that that's not everyone, and that in general, this is more of a yes and, again, where we're not restricting people to make these choices on their own behalf, but there's a lot of evidence out there that shows some, yes, broad general investor education and literacy that we'll talk on with the next recommendation can help, but that's not going to by itself solve a lot of the structural challenges that we have in our financial markets here in our country, and that some just-in-time communication that is layered, seamless, clear, can help us, dare I say, think a little slower, like Daniel Kahneman taught us, take a breath or two, and maybe reassess, is this decision still the best decision for me and my financial goals?
Okay. Andrew, I don't know if you care to comment.
Sure. Just in the course of thinking about this, I think it's been also kind of helpful to think about kind of the two distinct tracks of retail investors that, we may be concerned about and kind of distinguishing between the different sets. And so, when I think of, I would say there's two different sets, right? I mean, there's one who, maybe there is no interest in necessarily, right? I would say there's, two ways of losses, right? There, you could take a loss through simply taking inordinate amount of risk, but right, as long as that's understood, that sort of activity will, be happening, and that's unfortunately not something that, any sort of rulemaking could necessarily address, versus buying something and not being aware of the, of the payout structure and being misled, right? So I think there is that distinction there. And so just on that, latter piece, I would say that, any, just in time, just as Paul Somerset was just mentioning, is an important piece of this. This discussion did come up during the panel and the recommendations that we had on single stock ETFs, right? Because people were still mistakenly understanding the multiplier effect applying to the total return, not the daily returns of the product. And so, anything along the lines of, again, slowing down, but also I think with the rise of mobile trading, especially, anything that can, no one, people on mobile platforms are not going to have the same, readouts, or not going to be analyzing things the same way as a desktop typically. And so any sort of visual markers, any types of visual payout structures, anything like that, that can show what is not immediately intuitive, I think is going to be an important part of this. And so I would say, any of the rulemaking that's done from the SEC and FINRA should really also consider how do we visually deliver the information in a useful way to investors. So that's, I guess, my my thoughts here.
Okay, thank you. Any other comments or questions from the committee? Okay. Christine, Brian, thank you for that summary. Do we have a motion with respect to the recommendation?
I would move that the committee approve the recommendation.
Seconded.
Okay. Any further conversation or discussion on the motion? Seeing none, then we'll take a vote. All those in favor, say aye. Raise your hand.
Aye.
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 All those opposed, if you want to either raise your hand or on the record. I see
Aye.
one opposed. Anyone else? There are a couple of people who are, okay. Gina Gale, I see you're on. I have her vote in favor recorded.
Yes, yes.
Okay, thank you. And I can't tell about some of the others, but it looks like we have a recommendation that is passed. So thank you all. Thank you all for that hard work. Tremendous, tremendous effort by everybody. We are running on time. Our second recommendation is that of the Purchaser Subcommittee on Financial Literacy and Investor Education. We're going to discuss financial literacy to be led by Alice Steinbach, member of the committee or the subcommittee, along with the Purchaser Subcommittee Chair Jamila Abston Mayfield is on, and Vice Chair Paul Summerstad. So we'll have them lead that conversation. But before we begin, I do want to point out that and thank Alyssa Germain, Ted Daniels, two members whose terms recently expired, for their role in formulating and drafting the recommendation. Unfortunately, they don't have a speaking role today, but they played a key role in putting this all together. So Alice, let me turn it over to you.
Thank you. Can you all hear me? I've had microphone issues today. All good? Okay.
All good.
All right. Thank you. And thank you, Christine, and all those working with you for your support and acknowledgement of, because I think I agree that these two recommendations very much do go together, sort of in the Venn diagram of effectiveness. You need both of these to do what you need to do. On behalf of the Investor as Purchaser Subcommittee, and as well as former IAC members Ted Daniels and Alyssa Germain, who played a key role, as was stated, in the formation and drafting of the recommendation regarding financial literacy and investor education, I am pleased to present this recommendation to the committee for its consideration. So I'm going to say a few words about this recommendation, and then I'm also, at the end, I'm going to take just a moment to address Commissioner Peirce's suggestion that we include not only, or consider including not only starting this education at the high school level, but earlier. This recommendation addresses both financial literacy and investor education. These are concepts that go hand in hand, but are not precisely the same. Financial literacy means mastering the basics of how to use and maximize money so that sound financial decisions are made regarding the use of financial assets to accumulate retirement savings, create wealth, and understand the value of a diversified investment portfolio. Investor education is more specific, as it involves a clear understanding of the risks and benefits of investment opportunities. It is what makes the disclosure framework function as intended to increase confidence and fairness in the market. Moreover, the recommendation is in line with the stated mission of the SEC to protect investors and maintain fair, orderly, and efficient markets. It is consistent with the SEC's stated values. In pertinent part, two of the SEC's values are as follows: excellence. We are committed to excellence in pursuit of our mission on behalf of the American public, and effectiveness. We strive for innovative, flexible, and pragmatic regulatory approaches that achieve our goals and recognize the ever-changing nature of our capital markets. Finally, the SEC has recognized that the securities laws require it to engage with the investing public directly and on a daily basis through a variety of channels, including education programs. There has always been a need for financial literacy and investor education, but the need seems more urgent now than ever. As we heard earlier today during our meeting and previously at our December 2023 panel, participation in the markets is increasing rapidly. even more rapid is the development of technologies that create easy access to the markets by investors, and conversely, to investors by those seeking their money. Add this to the increase in complex financial products, and it appears less and less realistic to assume that these investors will understand or know what to do with all the financial information they receive. Our December 2023 IAC panel to address this need consisted of 1, experts in researching the distribution and impact of financial literacy, and 2, leaders promoting financial literacy through various programs and strategies. Based on the information received from the panel and after further independent research, we began crafting the recommendation in February of this year. Since then, the recommendation was reviewed, discussed, and revised by the Investor as Purchaser Subcommittee, and later distributed to the IAC as a whole for further comment and revision. This recommendation acknowledges the existing efforts and resources provided by the SEC through its Office of Investor Education and Advocacy. The recommendation also recognizes that there are a large number of other organizations, schools, and some agencies who provide quality education in this area. These sources currently are varied and scattered. Some states, for example, require completion of an independent personal finance course in order for students to graduate from high school, while others require inclusion of personal finance in an existing course, and still others require neither. This recommendation suggests that the SEC not only increase the allocation of its own resources to this effort, but also leverage and support the work of these groups. Both the efficacy and the reach of resources like investor.gov could be made more robust in this way. This recommendation also asks the SEC to work to increase the visibility and accessibility of quality personal finance and investor education resources multidimensionally across the wider population and throughout each person's lifetime. While the number and immediacy of sources of information for investors has perhaps never been higher than it is now due to social media and cell phones, investors might only find the reliable information they need or even know that they need it in any particular circumstance by chance. We believe the SEC has an opportunity to take a leadership position here to fight against the ubiquity of misinformation by making quality resources better known and just as accessible. Moreover, the recommendation suggests ways to give investors and potential investors access to financial decision-making tools and unbiased information in real time when and where it is needed. These types of tools are not new to the SEC, and in fact were inspired in part by the work done recently on index-linked annuities by the Office of Investor Research. The recommendation does not make specific suggestions with regard to the source of funding for these initiatives. The IAC is not taking a position on resetting existing priorities. That is, we would not ask that resources be taken away from other programs. Instead, we believe that an education initiative is important enough so that additional funding should be sought to cover its costs. It is also possible that increased investment in financial literacy and investor education could eventually lead to reduced investor harm and a resulting dividends of savings and enforcement. Efficient resources require that reliable financial and investor education resources be made easily available to every investor, new and old, participating in the markets. We are confident that the SEC can use the powers and resources at its disposal to use the suggestions in this recommendation to make that happen. As for Commissioner Peirce's suggestion that we begin before high school, I want to reference a couple of different sources for why that was not specifically included in here. First of all, I would like to say, go for it. If you want to start teaching kids at an earlier age, and if they want to devote the resources to doing that, awesome. However, our goal in this recommendation was to give the SEC what we thought would be the most practical and most effective and biggest bang for your buck, concrete suggestions to increase financial literacy and investor education. And doing this at a younger age runs into some specific problems and challenges in that regard. For one thing, elementary schools are already resource poor, and they're busy trying to take the resources they have, teaching these kids to read, teaching them basic math skills, which of course are then useful for financial literacy, and increasingly finding themselves also having to teach these kids some soft skills, ways to deal with anxiety and other emotions, and to not make impulsive decisions. Again, things that are useful for financial literacy, but not specifically within that realm. Having said that, there are organizations that have put together good curriculum. We're teaching kids simple, basic financial knowledge. And at the university level, I spent 6 years teaching elementary school teachers how to use those materials to teach elementary kids those basic lessons. But again, those teachers are very stretched in terms of how much time they can devote to that. And at the high school level, those kids are primed to learn financial literacy because they are working, they have their own money, sometimes for the first time, and they are on the cusp of moving independently out of their households or trying to save for specific big things in their lives, like college or a car. They are ready to learn this. You will find a kid who, slept through Romeo and Juliet in their English class, but they are up for that financial literacy class because this is something they can relate to. And people learn things best when they can relate to them, which is why we think that just-in-time access to financial education resources is so important. You are motivated and will learn it best when it is the most relevant to you. So to get the biggest bang for your buck, we really feel like high school and beyond, so not just within the school system, but high school and beyond whenever people need it. That's when we need to get people to access to good quality financial literacy and investor education. And with that, I will, open us up for comments, questions, snide remarks, as I used to say in my classroom.
Alice, I'm going to jump in right behind you and thank you, first of all, for that wonderful overview of the recommendation and for jumping in there and giving some feedback on Commissioner Peirce's comments. You, Alyssa, and Ted did a tremendous job with this one. And I also want to thank Brian Shore for making us stay on schedule, Paul Roy for challenging some of the suggestions we had and helping us fine tune them. Paul Summerstad, you jumped in near the end to help steer this when I was a little bit tied up. And then I honestly mean this, nearly every committee member responded with something. So I appreciate just the response. We got a lot of responsiveness and a lot of passion around this one. And then want to thank Danielle. Danielle, you helped us to make sure that the Office of Investor Education and Advocacy, that we didn't have any issue with them and we had the facts right in here. And so thank you for helping us do that. I also, Alice, want to address some of Commissioner Peirce's comments. I thought they were great. I appreciated her bringing them up. And I too love the idea of starting sooner, but I agree it's harder to standardize. It just creates some of the disconnect, I think, that we know we can establish from a high school perspective and beyond. But there are a number of programs out there. And so if there's a way that we can get those to be more exposed via the SEC's OIEA office or something like that, I think that totally makes sense. And we can come up with that list because I know 3 offhand. So it's not a not do it, but I don't know if it's a let's use further SEC resources to build it out. All right, so I think that's probably why, as you have already addressed, we abandoned that approach. But I also wanted to comment on her point on the potential dilution of other firms' financial literacy programming and their materials if we include some of that in and we offer it. I would love the wealth managers, the asset managers, for them to do programs as well, educating obviously clients and investors, but also, the high schoolers and college students. I don't think it dilutes it. I think this is an and. I think this, let them continue to create and be creative. I personally love the idea that the SEC would have a standardized approach to this. And if they want to focus on one particular product or something they really love in financial literacy, they can do that, right? So, I like the suggestion from a perspective of more is better, get everybody involved, don't shut down their, creativity. But standardization and making sure everyone has the same access to the basics is what we're going for with this recommendation. I think you would agree, Alice. And so I want to stand strong on that the SEC still needs to be the forerunner here in this. So I did want to address that as well. Finally, Commissioner Mark Udea made a comment about advisors kind of driving the learning for financial literacy. I don't know if you remember that, Alice, near the end of his commentary. And I love that idea too. Like, hey, they're already doing it. They already have programs. This is the core to their job, right? When they're suggesting a new product or a new investment strategy for their clients. And I think that that is a part of the fiduciary duty already. The idea that they're suggesting best interest products, maybe he thinks we should, include a step further that they're educating very thoroughly on those products and maybe educating high schoolers. We hadn't considered that. It's again, not like, no, I don't think that makes sense, but I think we really did want to focus on getting high schoolers educated, getting people at an opportunity to have the same access to information at a time where they're hungry, and where if they don't necessarily sign up, to be a client of Edward Jones or Fidelity, they don't lose out. So I wanted to kind of drive that point home as well. So said a lot there. Hopefully you agree with all that, and thank you again for leading this recommendation.
Thank you, Jamila. I do agree with everything you said. I think the focus of this recommendation that Ted and, well, that all of us had when we were going through this was to make sure that everyone at least has a basic level or a basic level of access to this kind of education. So if you have a financial advisor, great, but not everybody does. We don't need a broker to buy stock anymore. You just go online and do it. And so you don't even have that, gatekeeper educating you. So we need to start at, the place that everybody goes through is high school or earlier, great. And then stay with it, so that as people are going through all of their important life stages where they're making these big decisions, make sure there's at least a minimal level of access to good quality, consistent financial education. Brian.
Yeah, I just wanted to join in the praise of this recommendation and just make an important point, I think, about trying to bring more resources and focus to financial education at the high school level, something that I've been on and off involved with for about 30 years now. The real impact that I think we could make as a country on financial literacy would be to ultimately have curriculum standards in the high schools for financial literacy in the same way we might have for math, reading, science. And there's been a lot of challenges in establishing that. One of the biggest of which is teacher familiarity with the material and a willingness for the school board to feel comfortable adopting curriculum standards like that along the lines of financial literacy, given that kind of gap in teacher readiness. So the more we can do to use existing resources, bring that knowledge into the high schools, obviously first at the teacher level and ultimately at the student level, begins to remove those barriers to what ultimately can become a standard curriculum, standard-based approach to addressing the financial literacy crisis in this country. And I really commend all of you for thinking about those issues and emphasizing the potential benefits of bringing financial literacy to the students at that level.
Thank you, Brian. And you make a really good point about teacher readiness. It does require an investment in some teacher training, but those materials are out there already, and this recommendation does encourage the SEC to leverage that, to make use of what's out there. So thank you. Christine, did you want to weigh in?
Yeah, so with respect to the high school and college and university piece of this, I do think it's important. There is education happening to a large extent. It is primarily focused on financial education. I really appreciate the fact that this is purposefully including investor literacy. I know, when we educate our students here, so much of it is with respect to budgeting and borrowing, but not really on investing. And I think an unanticipated side effect of this type of educational program will be increasing financial and investor literacy of teachers and professors. So I think you're actually going to reach a much larger audience than even intended by the recommendation in the first place. And I also really appreciate the creativity of the recommendation in terms of taking what we heard about this morning from a concerning perspective and using it for good. Using financial influencers to positively impact younger and newer investors, to introduce them to the financial resources available at the regulators, and to add credibility and trust to the regulatory materials that are already available. But through the sources, we know the younger investors actually do trust.
Thank you, Christine, and I appreciate your comment about, when the university and high school students get taught, it doesn't just teach the students, because when you teach, you learn something really well. But that can go even further. Those high school kids take that knowledge home to their families. And if those, especially our families that haven't had access to that kind of information before, that can have a really positive knock-on effect for those families to have access to that through their high school student or through their college student. So thank you for that. I got my two Pauls here. Paul Roy, how about you?
Yeah, thanks, Alice. And again, thanks to everybody who worked on this. And, as we worked on this, I think we know there are a lot of ideas out there about promoting financial literacy and education, and we wanted to try to, think outside the box. And Christine just noted one where, every time I cut on the TV and I see some celebrity touting, a gambling site, or celebrities touting crypto, I don't see why the SEC can't get some celebrities, athletes to promote investor.gov. And I think those are the kind of out of the box things that we have in the recommendation. And then when we started working on this, I had no idea that there was a Financial Literacy and Education Commission, which the SEC was a part, with 23 other federal agencies, including the Department of Education. And, their role is to set national strategy on financial education policies, and coordination. And hopefully those folks in those agencies will look to our recommendations that we have here. And, we suggest that they promote some funding to address the 25 other states who don't have financial literacy programs in place. And that, as Alice pointed out and Brian pointed out, to educate the teachers so that they can work with their students and promote financial literacy and education. But there's gonna have to be some incentives to do that. And so hopefully folks will pay attention. Thank you.
Thank you, Paul, and thank you for all of the out-of-the-box thinking that you helped us do in all of that. I would say you were one of the main sources of our most creative ideas, so thank you. My other Paul.
Thank you, Alice, and thank you everybody involved putting this recommendation together. Two really quick points on the sixth part of the recommendation, kind of partnering or communicating with the DOL. Again, this is part of my day job. We're seeing a significant improvement of employer workplace plans offering, investor education, literacy, and not just white papers that nobody reads. We're talking quick, plain language videos in different modes. So that continues to get better, but I think there's even more room for improvement. And then last, Really appreciate the perspective of having advisors or experts, financial professionals also provide some of this education. I don't know if that's as practical from a high school level in the immediacy, but I will share that at least at the grassroots level, there are many of us that are SEC registered advisors that do provide pro bono work in this space to help others, primarily in the not-for-profit world.
Yeah, and that is so appreciated. You know, again, it's just lucky if somebody comes across that resource. I wish that everybody could have that, because I'm sure learning from you and others, you know, in your world there is fantastic. I might even want to sit in on one of your education sessions. But, you know, we want to be able to give everybody an opportunity to get that kind of access. Colleen.
So I thought the recommendation was great, and you know, thank you guys for putting it together. I just had a question based on, so California is actually voting on this, and as you probably know, in November, as to whether this should be a high school requirement. And one of the, you know, sort of point against is, like, we already require a lot of classes in high school. There's not that much movement in the curriculum and not a lot of capacity to add more. And so I'm curious generally for your thoughts, and also one of the solutions that people have proposed is to just add financial literacy to econ. And if somebody already has to take a semester of econ, to spend part of that on financial literacy. And I don't know, I was wondering when I was reading through the recommendation, if, like, the states that do mandate financial literacy, is it a standalone course, or is it sort of jumped in together with econ? And is there any kind of research on best practices?
So across the U.S., it's a mix of all of those things. Some states have it as a standalone course that's required. Some states have it as part of econ, or some are even less specific than that. They just say you can incorporate it into another course. Okay. So that, you know, could be a math course. I've seen it put into a health course where you learn about budgeting and, you know, saving and things like that. So the answer is all of the above. Okay. They've done all of it. And it does, you know, come into a battle of resources. There's only so much time in the school day. There's been a really big push for STEM, you know, all the science and math and engineering. But I think high schools and educators are beginning to recognize the importance to our economy of learning, I guess, entrepreneurship skills and basic life skills that you usually would learn in your family, but people are not learning in their families. And both of those things require that kind of financial background, such that this should be considered more of a basic course and not just an add-on to something else. And I know, again, that competes with reading, it competes with math, it competes with history, which is taking a hit all the time as all of this science and math comes to the fore. And as a social studies department chair, that hurts my heart a little bit. But it's a basic life skill. And if we want to be able to say in our country that everyone has an equal shot at success, then everybody needs to have equal access to this kind of education. So I do think it is that basic, and that would be the argument that I would make back to that. But maybe Brian Helmer, in your advocacy of this, you've run into this as well. I'd be interested to see what your thoughts are on that question.
I don't have a whole lot of thoughts on that question. I haven't run into that too much, so I'm gonna pass on that one.
All right, sorry to put you on the spot there. I thought maybe you'd gotten some pushback in your efforts to try to get this going.
Well, we definitely have. I'm trying not to alienate some of the people that I'm still trying to make friends with. So yeah, we have we have definitely gotten. Everybody's not on the same page. Let's leave it at that. So yeah, I think every little bit helps to overcome these hurdles, and I think that's what I appreciate about the recommendation.
Brian, are you talking? Sure.
James, did you want to say anything? Nope. Any other further comments?
Yeah,
I see
Brian.
Leslie. Leslie and Paul? Paul?
Sorry, I just had a really quick one. I just wanted to mention that I support this recommendation, but also caution that scaling and expanding programs cost money. The recommendation highlights how small the financial literacy staff at the Office of Investor Education and Advocacy are. Can you imagine how much they would get done with more human and other resources? I hope that Congress will take note and provide funding for this important function.
Thank you, Leslie.
Yeah, Brian, on with regard to, Commissioner Purse's comment about, or maybe it was Commissioner Ueda, with regard to the industry stepping up with regard to financial education. I would just point out that the SIFMA Education Foundation, has educational programs that do extend down in beyond high school, below high school. They run the stock market game. They have other programs, and this is a shameless plug, but the SEC Alumni Association is partnered with SIFMA Foundation to get SEC alumni to work with them to go into the schools and provide financial literacy training. So there are elements of the industry that are stepping up, and so are SEC Alumni Association members.
Okay.
Yeah, I really don't think the SEC has to reinvent the wheel here. If they did, that would take a tremendous number of resources. There is good stuff out there. There are great organizations out there. It's been done. And I think the SEC can make use of, those kinds of partnerships to extend the resources that they have to make them work as hard as they can to get some of this done.
Okay. I want to thank everybody for a very, very robust conversation and discussion. Alice, thank you for leading that summary, and Brian. Paul, if there are no further questions or comments from members of the IC, do we have a motion to approve the recommendation?
I will move that we approve the recommendation.
Okay. A second?
Second.
Okay. All in favor?
Aye.
Aye.
Any opposed? For the record, I also note that Gina Gale is in favor. Okay. Thank you very much. We move on. It's now time for our subcommittee and working group reports, and we'll receive brief reports from each of the subcommittees and working groups. If we might, in alphabetical order, James, would you want to start for the Owners Subcommittee?
Thank you, Brian. The Owners Subcommittee recently met, and we discussed this meeting in detail, and we also discussed future contributions to panel discussions in later rounds of SEC IAC meetings. And as a final item, we also discussed some movements within our committee, which we will talk about later. Thank you much.
Thank you. Next, Brian Helmer for disclosure.
Yeah, the main update I would have is that we continue to be busy. We contributed a couple of items, a recommendation and a panel to this meeting, and my thanks to Paul and Christine for all their efforts once again. I think we continue to explore new ideas about panels. We'll be working on formulating a recommendation around the Finfluencer panel this morning, as well as we head into the summer. So busy group, and we are also entering a period of transition as we get closer to my terming out later this year. So that's also on our minds, and we'll be working on that as well over the summer.
Okay. Jamila, on behalf of purchaser.
Thanks, Brian. Similarly, we met a lot getting our recommendation out of the door, but we met as well to talk about transition.
And we know there'll be more to come on that. That'll be public soon, and we're excited that we've got a solution. I do want to thank Leslie. If in the event that this is the last time we have her, she has been a force on our subcommittee as well as the larger committee. But thank you, Leslie, for always commenting, always giving edits, always reviewing, bringing the contrarian view. It was well needed, and we appreciate you, and we will miss you. So wanted to say that. I think next up, we hope to have a spotlight with our committee leading a panel next meeting as well. So that'll be coming, more to come, and Paul Summerstead is our fearless leader on that. I think that's it, Brian.
Okay, thank you. Roy?
Yeah, thank you, Brian. The Access and Inclusion Working Group met 3 times since our March meeting. We focused on the access and inclusion implications regarding the recommendations that we consider today, investor education and self-directed investors. And we talked about the investor inclusion issues in connection with today's Finfluencer and AI panels, which potentially could lead to some topics in the AI space in terms of whether or not AI will exacerbate the wealth gap between groups or close that gap or have the potential to close that gap. We also highlighted recent reports advanced by the SEC's Office of Minority and Women Inclusion. And I would note that the SEC yesterday kicked off its biannual collection of diversity self-assessment submissions from regulated entities. And the commission collects this data and then uses it to put out information on progress and trends on diversity-related issues. Unfortunately, 2 years ago, only 9% of the regulated entities submitted reports, and hopefully with the revised report, there'll be a significant increase in those submissions. So with that, Mr. Chairman, I'll conclude my report.
And thank you. Andrew Park for market structure.
Thanks, Brian. So since the March meeting, the Market Structure Subcommittee met twice on April 18th and also on May 16th to discuss and recap the panel that Gina Gale Fletcher had wonderfully put together and moderated back in March related to the equity market structure proposals. And so we discussed some of what we heard the panelists talk about. In terms of, we got a good sense of where we thought we heard areas of consensus from the panelists in terms of the issues raised around the order competition proposal, and also we seem to hear some consensus around tick sizes of half a penny. But we still want to spend some more time in the coming meetings to talk through these proposals some more and what we heard, and start to think through some of the other areas where there isn't immediately any sort of consensus, and discuss what a recommendation should look like there. And so we expect to meet a few more times to go through what else should be included in a future recommendation. Separately, the subcommittee is also working on a recommendation following last June's panel that was held, looking at potential ways that the SEC can use its existing authority to screen private market investments, outbound investments in countries of concern. And so 2 months after the panel was held, we saw that the White House issued an executive order on this exact issue. And so we are thinking through ways of making sure that investors, private market investors, have the transparency so that they can better assess a lot of the geopolitical risks and other types of risks associated with sanctions and other types of funding of sensitive technologies in countries of concern that are quite relevant and material for them. And so we are discussing some of the recommendations and finalizing those in preparation for a very near-term meeting. So with that, I'll turn it back to you, Brian.
Thank you, Andrew. With those reports, that concludes our subcommittee and working group reports and brings us to the end of this meeting. I would like, as always, to thank a number of people. First, the investor advocate, Christina Martin Verbita, I'd like to thank the SEC staff, Mark, Tony, Danielle, and the rest of the supporting team for keeping us running smoothly. And I'd like to thank my predecessor, Christopher Mirabale, for such a smooth transition, and Leslie Van Buskirk, who we've noted, who was former vice chair of this committee, since this may be her last meeting. With that, I think we're ready to bring this meeting to a close. And I thank you all for attending today. It's been a spirited and terrific conversation, and I look forward to continuing it at our next meeting, which will be in September. Thank you very much.